Good afternoon, everyone. My name is Danielle McNichol, and I'm General Counsel and Director for the Center of Leadership here at Newman University. Welcome to today's topic, Sexual Harassment in You, what every employer and employee needs to know. Today, I have to tell you, I'm very excited about the legal panel as well as the human resource consultant panel that we have. This is a great group of professionals. We're going to be talking about everything from the basic to sort of the current climate, and we're going to have the benefit of actually having audience participation for a mock trial. So it'll be it's going to be a very exciting agenda. It's going to move, I would think, very quickly. We will be taking questions from members of the audience, but I would ask you to please fill out an index card, and I'll make sure to pass those along to everyone. We are live streaming this, so that's the reason why we would request to do that. So we're making sure that our audio is going to be able to be viewed again on the internet. If you take a quick look at your agenda, if you'll see on the bottom of there, the website, live stream and presentation materials will be available to you at Newman Center for Leadership with the number 4.com, Twitter at Newman Leaders, and hashtag Newman Leads. We want to thank Fisher Phillips, Cozen O'Connor, Exude, as well as Apple Walnut Cafe for all of the participants here today. A few quick housekeeping items that I want to make sure everyone's aware of. There are 3 continuing legal education credits that are available. How that works, please fill out and make sure you've signed in and you fill out your CLE form. Put one of the carbon copy versions back on either of the registration tables before you leave, and then we'll be contacting you about what the next step would be about. It's $3 per credit that has to be paid to the Pennsylvania Bar Association. So I'll contact you with next steps just to finalize that process for you. There are also human resources credits that are available. You just need to access the number that's available on the table. Feel free to take one of the forms along with you, and they'll work through the process of confirming your CLE credits as well. We also have CEU credits available through the Pennsylvania State Board of Social Workers, Marriage and Family Therapists, and Professional Counselors. And again, that information is available on the table. Please feel free to take one. We will confirm your participation today. We will be actually taking a brief break, and again, the reason for that brief break is to give everyone a chance to use the restrooms. The restrooms are located immediately outside of the doors here and to your right-hand side. We have 2 emergency exits at the front of the theater, one on either side of the theater, if that would be necessary. And again, today's great food was provided by our sponsors, Apple Walnut Cafe. We appreciate them very much. Want to do 2 of our, what I would call our commercials. The first being our next event will be on June 13th from 10 to 1 o'clock, that's Open Records and Right to Know. And that'll be featuring former Governor Ed Rendell, the Honorable Dominic Pileggi, and the Executive Director of the Open Records Office, Eric Arneson. We'll have representatives from KYW Radio, as well as John Bear and a number of other associations that will be here. That's going to be a very interesting topic for those folks that do use the Right to Know and Open Records, so please check that one out. Also, a reminder, Wardrobe for Work program is accepting gently worn business, casual, and professional attire from community members. The program provides 3 days of outfits, the first day, the first interview, second interview, and the first day of work. Since its inception 18 months ago, we've collected over 20,000 pieces of clothing, and we're blessed to have a community that does that, and we look to return that back to community members as well. So far, we've placed about 5,000 pieces of clothing back to the community. So if you're interested to host a bin, to donate, or you're aware of an organization that may benefit from the clothing, please feel free to contact me. My email is available on the Center for Leadership, but it's mcnichod@newman.edu, and I'll be happy to work with whomever on that. So those were my commercials. So the next thing, we're on to our program for today. Our first segment is going to be focused on the current landscape, sexual harassment law, and a mock trial with, again, as I mentioned, there will be some audience participation in this. So the legal experts that we have here, I would welcome you have a chance to take a look at their bios that are on the website. We have truly 3 experts in the field of employment law, primarily on the employer side, but also in the employee side. First, we have Lori Armstrong-Halber, who's a partner at Fisher Phillips. Second, Samantha Bonanno, who's also a partner at Fisher Phillips. And Dave Hackett, who's a member at Cozen and O'Connor. So I'm going to turn the program over to these professionals today. Thank you so much.
Thank you. Is it already ready? Yep, you're all loaded. I'm all loaded. All right, we're locked and loaded. See if this works. That doesn't look right. Hold on. Yep. I can't see, though, because I need my glasses. So while I'm doing this, let's take a poll. How many of you are attorneys? How many HR professionals? How many management folks? What's this one? No. Yep. F5. Very good. Oh, we got this. All right. So first of all, thank you for joining us this afternoon. I am Lori Armstrong-Halber, and Samantha and Dave are up here with me. We're going to start off with a little video, and then we're going to give you some legal primer. So for some of you, it'll be new stuff. For the lawyers in the audience, you'll be thinking, oh, I remember the Barbary class. And then we are going to do a mock trial. We're going to walk through a sex harassment case so you can kind of see how it really works. And then we're going to spend some time after that giving you some best practices from the legal perspective as employers and managers in dealing with this landscape. So with that...
In the original report, 8 women accused Rose of a range of allegations, from groping to exposing himself to lewd phone calls. In a statement, Rose apologized, adding in part, "I am greatly embarrassed. I have behaved insensitively at times, and I accept responsibility for that, though I do not believe that all of these allegations are accurate." The Washington Post now says more accusers are reaching out, a lot more.
Within hours after the publication of our story, we already had, more than a dozen emails from women who wanted to come forward.
Reporter Amy Britton says 5 of the original accusers decided to remain anonymous, fearing Rose's reaction.
They were concerned that he would possibly try to derail their careers if they spoke out.
After a 4th former staffer came forward with allegations of harassment. This time, 3 separate incidents of alleged sexual misconduct almost 20 years ago.
He just sat there, he didn't say anything, and he just took off his clothes, down to his, not naked, down to his skivvies, like you would do in your bedroom.
I will not.
The show Kevin Spacey is best known for, House of Cards, will end after a 6th season, Netflix announced today. The 2 companies behind the hit show said in a statement they are deeply troubled by the new allegations against Spacey, and that executives met this afternoon with cast and crew to ensure that they continue to feel safe and supported. Kevin Spacey was a 26-year-old on Broadway when a 14-year-old boy, also appearing on Broadway, told BuzzFeed Spacey invited him to a party at his apartment. "He picked me up like a groom picks up the bride over the threshold," actor Anthony Rapp said, "and then he lays down on top of me."
The judge told Nasser he can expect to spend the rest of his life behind bars.
You guys have seen all these clips.
Trust that you've had.
I'm not going to spend the entire time. You've watched the news. You can't turn the TV on without seeing something about the Me Too movement and without hearing about some person who's now being accused of harassment. And one of the things that you should know as either a manager or somebody who defends companies in these types of claims is you can expect a spike in claims, and we're going to show you some data, because of the awareness that comes along with this. There is a difference, though, in this movement from what we've seen before, and I'll talk about that in a moment. So 1991, Clarence Thomas hearing, Anita Hill, right? It was all over the news. It was the first real public discussion about sex harassment that ever occurred. And this is a clip from the Chicago Tribune talking about how women started coming forth after watching those hearings. And if you look at the bottom part here, it says in the last quarter of 1991, 1,244 claims of sexual harassment were filed with the agency. That's the EEOC, which is the federal agency that enforces the anti-discrimination, anti-harassment laws, as compared to 728 in the same period the year before, which was an increase of 71%. So after the Anita Hill, Clarence Thomas hearings, we had a 71% spike in claims. It's really small font, but this is kind of the gap period between the Anita Hill and what we're going to talk about next. And you can see there's a pretty steady level of complaints ranging from 20 to 30,000 claims filed with the EEOC every year. This is only the federal data. Every state has its own agency, and if there are claims that are filed only with the state agency and not simultaneously with the federal agency, those claims are not included in this. So the overall national claims are significantly higher. And in some states, not Pennsylvania, although it is true in New Jersey, you don't have to file a claim with the agency first at all. We'll talk about that in a minute. So what happened last year? We had an explosion in the Me Too movement, in harassment awareness, starting with Harvey Weinstein, and then from then it just spiraled. And every day we were seeing more news clips like the ones we started with. Since that, the EEOC has already received an additional 27,000 additional claims. That's the total amount of claims that were filed in 2007. And compare that with the spike of 1,244 claims after the Anita Hill, Clarence Thomas. 27,000 claims. So women are speaking now, and this is what I was going to say is different. So we had the Anita Hill, Clarence Thomas, we had the Bill Clinton, Paula Jones, Monica Lewinsky, and you saw spikes after that, but you didn't see the connective movement among women who are now using their voices to speak about inappropriate behavior in the workplace. And we are going to talk about the fact that this is not just women. You can't harass against men. Today's topic is about sex harassment, but please understand that harassment is prohibited on the basis of any protected class. We won't be covering that specifically, but you should know that. A solid majority of Americans, 64%, say that sexual harassment in the workplace is a serious problem, according to a recent poll. That number was less than half only 7 years ago. So what are the concerns? 64% of Americans see it as a problem. 88% of women have been harassed. Now, a little exercise that we did in our office before, believe it or not, the Me Too movement started becoming so public. One of Samantha's and my colleagues came in and she was relaying a story about a friend of hers had gone to court and somebody mistook her for the court reporter. Most women lawyers have had that happen at least once, and we were just sort of like, ugh, can you believe that? Rolled our eyes. And the male partner who was with us said, does that really happen? And we were like, yeah, it happens all the time. So we started to have this discussion, and I said, I challenge you to ask every woman you know, and I guarantee you almost every one of them will have at least one and probably multiple stories of inappropriate or harassing conduct that they've endured. I have 5 that I can think of off the top of my head, which would be fairly egregious. I won't share them with you now, but we can talk about them later. So that's that. And then I said to the male partner, I said, how about you? Do you have any story or anything common that you can connect to us that you've experienced? And he said, well, no, actually I don't. I said, well, let's ask the men. So we did this kind of, ad hoc study where we started surveying people, and we found that almost every woman had a story, and most men didn't have something that they'd experienced that had been like that. And I think part of the challenge is we have to have us meet and understand the perspectives. All right, 79% of the victims are women. This kind of bears out what I was talking about. 21% are men. 27% experience harassment from a colleague. 17% experienced it from a superior. 12% received threats of termination if they didn't comply. That's quid pro quo, which we'll talk about in a minute. 2/3 of the victims were not aware of workplace policies regarding sexual harassment. This survey, by the way, this information is recent. This isn't from 20 years ago, and it's a little disturbing if you are a management side lawyer or an HR person that 2/3 of the workforce don't know about policies prohibiting harassment. And half were not aware of what department or person should be contacted regarding harassment. 1 in 3 women ages 18 to 34 has been sexually harassed at work. And 81% of women experience harassment in some type of verbal form. Now, here's some interesting statistics. A much smaller sample of people, 750 men were surveyed, and many men indicated that they weren't really sure what sex harassment was, they weren't sure where the line was drawn, or what amounts, what would really constitute harassment. 1 in 3 said that they didn't think catcalling constituted harassment. 2 in 3 don't think repeated unwanted invitations to drinks or dinner would constitute sexual harassment. I can tell you from personal experience, I had to defend an individual who is a C-suite level person at a company who was accused of harassment. And when I met with this individual, I said, well, tell me about what was going on. And he said, well, I thought that and it was the HR person who was the plaintiff. And he said, well, I thought she was attractive. And I said, okay, well, she's accusing you of harassing her, that you asked her out. And I said, tell me about that. And he said, well, I asked her out. I said, I know, I don't want to be inappropriate, but I think you're attractive. And if you'd like to have dinner, I'd like to have dinner. Just let me know. And I said, what did she say? He said, she'll get back to me. I said, okay. I said, then what? He said, well, I followed up with her. And I said, okay, well, what did she say? She told me she'd get back to me. So we went through this a few times. I said, how many times did you follow up? He's like, I don't know, 15. I said, okay, here's a clue, not legal, just dating. That means no. But, it bears out. And he was drawn into this harassment suit in part because of his conduct. Nearly 1 in 5 don't think sexual harassment is a fireable offense. So 20% of the men in this survey apparently don't see it as something that is a significant work rule violation. These are the top 5 industries with the highest sexual harassment incidents: business, trade, banking, and finance, sales and marketing, hospitality, which is anybody who worked in the restaurant business will be of no surprise, civil service, education, lecturing, and teaching. So let's talk about the law. In my free time, I corrupt young legal minds at Temple Law School. So I try to make this sort of straightforward. We're not going to read the statute, but this is the source material for those of you who like to go back to the source. You'll notice the red highlighted portion, which says that it's an unlawful employment practice to discriminate in terms and conditions and privileges of employment because of that person's protected class, in this case, because of someone's gender. So what does that mean? It's raining again. Sexual advances, requests for sexual favors, verbal or physical conduct of a sexual nature that disrupts someone's job performance or creates an intimidating, hostile, or sexually offensive work environment. So we really sort of think about harassment in two components. We think of the quid pro quo, which is sort of this, it's not sort of, it's the sleep with me or you're fired scenario, or you get an extra benefit if you comply. And this is the one where it becomes, I don't know why, but it seems to create more of a challenge for people to understand. This is the hostile work environment. This is the legal definition. It's when a work environment is overcome with either severe or pervasive. Severe, one time really, really bad. In the state of New Jersey, hanging a noose and using a racial slur one time could be sufficient to constitute a hostile work environment. Or pervasive. 1 or 2 emails, not that big a deal. 1 or 2 emails a day, time and time again, over a longer period of time, pervasive. Unwelcome behavior that's directed at someone because of his or her protected characteristic, that is offensive, hostile, and or intimidating, such that it has the purpose or effect of unreasonably interfering with that individual's work performance or adversely affecting the terms and conditions of their employment. So there's kind of 3 court decisions that kind of frame the way the courts analyze and look at harassment. The Vincent versus Meritor Savings was the first Supreme Court case that recognized harassment as a form of discrimination. And it involved a bank manager and her supervisor who had engaged in a sexual relationship. She claimed at times it was, I'm going to use the word consensual, and at times it was not, i.e. she alleged that he raped her on certain occasions. And the Supreme Court looked at this and said, look, it's not about consent, it's about welcomeness. And when there's power inequities in a relationship, it's a different analysis. The next case was Harris versus Forklift Systems, which really talked about looking at severity versus pervasiveness and the totality of the circumstances in determining what constitutes a hostile work, an unlawful hostile work environment. And then Ellison versus Brady talks about impact, not intent, and the reasonable woman standard, which I'll come back to in a minute. Pervasive. If you walked into your office one day and you found stickies all over the place, you might be annoyed. you might think it's funny, assuming it didn't contain kind of slurs or pornographic images or whatever. But if you walked into your office every day and had to spend an hour pulling all the stickies down, that would be pervasive. So the conduct doesn't necessarily have to be sexual, but it has to be targeted and it could be hostile, intimidating, or offensive. Back to that. This is actually another case I was involved with really early in my career. It's sort of interesting because when I see it up on the slide now, I think, oh my gosh, how can anybody, it's got this impact, right? But at the time, and let me give you the scenario, these guys were working down at a casino in Atlantic City. They were banquet workers. So they were cleaning up after a banquet, you know, the big round tables with the giant white tablecloths, and they were pulling off the tablecloths, and they were wrapping themselves up in the tablecloths. And the one guy said to the other, hey, you look like a KKK guy. And the other guy goes, no way. And they like evolve into this, or should say devolve into this, in their minds, Saturday Night Live skit. And you'll note it's 3 people, 2 white guys and a black guy, that have created this, you know, I guess they thought they were Chris Rock and Jimmy Fallon or whomever. And they went down the hall to another friend of theirs who was black, who was breaking down a different banquet, and brought him in. And he was extremely offended. So now why do I tell you this? Does anybody here think that those 3 guys were trying to be hostile, intimidating, or offensive? Anybody? It's not about the intent, it's about the impact. Now think about this. Some people go, well, it should be about intent. I mean, I didn't mean to be offensive. That should be okay. If we made it about intent, everybody could get a get out of jail free card and it would be fine. You would just do what, like 8th grade, my 8th grade, they're not in 8th grade anymore. When my daughters were in 8th grade, they used to be like, Mom, I don't mean anything by this, but, or they would say, no offense, and then they would proceed to say the most offensive thing they could think of, because that's what they did, right? So we can't make it about intent, we have to make it about impact. All right, and with that, I will turn the clicker over to my colleague Samantha.
Make sure this works. Can you guys hear me? Yes?
Yeah.
All right, so let's talk a little bit about when employers are liable for actions of their supervisors. Employers are subject to vicarious liability, or they're liable for the conduct of others for a victim for a hostile work environment claim created by a supervisor. Sometimes the employer can set forth an affirmative defense, which just means facts they can set forth that will negate or mitigate the plaintiff's allegations if true, even if you can get out from under the consequences of the otherwise unlawful conduct. But there's no affirmative defense if there was a tangible employment action, such as termination or demotion, and some of the stuff we've been talking about, and we'll continue to talk about here. When there's no tangible employment action, the employer can raise the affirmative defense to show that the employer exercised reasonable care to prevent and correct the conduct, and that the employee unreasonably failed to take advantage of these corrective actions or the preventative measures. So to prevent, what's reasonable in that circumstance? I think everybody knows you need to have the policies that say you can't discriminate, you can't harass, but you want to make sure that they obviously have things built in for alternative routes of complaining. A lot of times it is the direct supervisor at issue, so if it's directly go up the chain of command and there's not an alternative route, you might be in some trouble there. You also want to make sure that you have an investigation plan in place, people know where to report, that sort of thing. And in terms of proving that the employee unreasonably failed to take advantage of these mechanisms, if they don't complain, there's a lot of suits I know that we see that plaintiffs haven't gone to HR, and they may or may not have a reason for that. Some of the numbers Lori showed earlier is kind of staggering, that some people don't even know whether there is a policy or where they should go to complain. But if you want to be able to take advantage of these affirmative defenses, you want to make sure that you do have plans already in place and actions you can take when you are alerted of such a claim. In terms of liability for coworkers, so that's a different standard. If the employer knew or should have known of the conduct and failed to take any action, then they're also liable for coworker or vendors harassment. And what is effective? That's any action reasonably calculated to end the harassing conduct. One thing I think I'm sure all of you have dealt with are retaliation claims. So you have the great plan in place, you have a prompt investigation, you do everything you're supposed to do, and then that employee comes forward with either a retaliation claim or maybe a supervisor comes forth and says they need to take disciplinary action against the employee. As I'm sure you know, Title VII and the other federal and state anti-discrimination statutes prohibit retaliation, which is discrimination based on making a complaint. And it doesn't necessarily mean making a formal complaint. It could be participating in somebody else's complaint, participating in an internal investigation, an EEOC investigation. Anytime that you are opposing an unlawful employment practice or participating in an investigation of that, it's protected activity. This is the Title VII definition. I'm not going to read it, but if you're curious, that's... Sure.
The one thing I was going to say, two things to the two recent points you've made. So when you have liability, vicarious liability, if the employer knew or should have known about the offensive behavior, what constitutes the employer knowing? Is that the CEO? Does the CEO have to know? No. Every supervisor that you have is considered standing in the shoes of the employer. So every supervisor, if they can't keep their head in the sand. So if they're aware of, if they're aware of, they see interactions that someone is doing, or they see things posted around the office place that are offensive, they now know that conduct, and the employer is charged with that knowledge. Similarly, if someone comes to a supervisor and says, listen, Fred is being, saying all sorts of crazy things to Susie that are really offensive, talking about her body and stuff like that. It's really inappropriate. That supervisor now needs to take action. And if the supervisor does not, that's a liability issue for the employer.
Pay attention when we're doing the trial, because there's some of that is weaved in, some of the facts go directly to the examples that Dave is giving.
Great points, thank you.
And the other thing I was just going to add is that this retaliation is probably maybe 7 times out of 10 is the more difficult thing that we deal with as defense attorneys in a case. And I apologize if I'm jumping.
No.
Is that that's the issue, is that it's the sort of like it's always the cover-up, right? That gets the government official into trouble. The same thing, it's the retaliation that is the issue of how someone's made a complaint or participated in an investigation, and now how are they treated after that? Right?
Yeah,
well, way to get rid of it. That's a huge issue for us in defending a case. It's much tougher to defend, and is a huge liability issue for employers.
Yeah, to that point, I know Lori went through some of the statistics earlier, and maybe it'll change this year based on the Me Too movement, but generally retaliation claims are much more prevalent than any other type of claim in terms of an EEOC charge. So in 2017, I think the number total was like 41,000 retaliation EEOC charges. The second in line was race discrimination at 28,000, so it's a huge difference. And part of that may be, the plaintiff doesn't have to prove that what they complained of was actually unlawful as long as they had a good faith belief that they were opposing or participating in an investigation into unlawful behavior. So what is retaliation? Engaging in statutorily protected activity, plus an employer taking adverse action, plus a causal connection, and you have retaliation, and that's not okay. Adverse employment, well, let's first talk about protected activity. I talked about this a few minutes ago, but it's anytime an employee is opposing unlawful conduct, It could be, you know, refusing to engage in conduct they think is unlawful. You know, if a supervisor's saying, hey, we need to make this hire, we really, you know, I'd like to get somebody young in there, let's make sure we're looking at our younger candidates. And if the employee says, you know, I'm not going to do that, that we can't do it that way, they've engaged in protected activity just as much as someone who's filed an EEOC charge. Threatening to file a complaint or a charge is also protected. And again, whether it's formal or informal, protesting some employment action, that's all protected activity. And in terms of adverse employment actions, we all think of termination, demotion, things that are a little bit easier to see. I know I get a lot of calls, it seems recently, on people that have made complaints maybe internally and are coming forward claiming retaliation with things that it's not such an easy determination. Whether having their office moved or suddenly being tasked with a few different duties that they've never had to do before and they don't think that's fair, and is it because of a complaint they had made or being part of an investigation? So it's not always that clear. You have to kind of drill down and find out why do they have these extra duties or sort of what's going on there. But just be aware that it's not always the easy ones that, you know, they were terminated or demoted. Causal link, I mean, the biggest, I think the most prevalent argument I see is timing. If it's a really short period of time, there's an inference that it's retaliatory. I think the most favorable cases I've seen are maybe 3 months that you at least don't have the inference of retaliation. But you know, it's something to think about because you will have employees that, you know, they appropriately do need to receive discipline, but maybe they have come forward recently. And you kind of have to deal with those issues to make sure you're dotting your I's and crossing your T's to make sure you can withstand any sort of retaliation claim. And that sums that piece up.
All right.
And with that inference that Samantha's talking about, that means that you as an employer cannot win summary judgment and that you're going to go to trial. So that if let's say it happens you took, somebody complained, you took discipline against that person 2 weeks later, now there's an argument, well, was that because of the complaint or was it because of some legitimate non-discriminatory reason? The judge is going to say, well, I can't decide that, that's got to go to a jury. So that's going to prevent you from winning the case, and now you've got to decide if you're going to spend the money and the risk of going to a jury trial.
All right, so the next couple of slides are for the non-lawyers or the non-litigators in the room. And then we're actually going to do a trial. We're going to need 4 volunteers to come up and serve as witnesses. Any frustrated actors in the room? It's all scripted, right? Literally all you got to do is read the answers.
Pete's sitting in the front, so Pete's going to...
So 4 of you are going to think about that because we're going to call on you otherwise. But for those of you has anybody never been to a jury trial before, ever? All right. So this is really what an employment lawsuit looks like. So for the couple of you who've never been to a jury trial, and for those of you who are familiar but maybe need a refresher, what does it look like? And then when I'm doing training for my clients, this is how I start. I go, a lawsuit is made up of 2 parts, time and money. And it's true, because you will lose a tremendous amount of time defending a lawsuit, and it will cost you a tremendous amount of money even if you win defending a lawsuit. So the best thing you can do is to prevent one. Now, you might do everything right, and there still may be the occasional disgruntled plaintiff, but you're going to be in a much better position to defend that at a much less expensive rate. All right, so for those of you who don't know how specifically harassment lawsuits work, and particularly in Pennsylvania, I'm calling it the subject, the victim, whatever, the complainant, may or may not make an internal complaint. Although Samantha alluded to the Farragut defense, there are circumstances where a complainant is not required to make an internal complaint. For example, if there's a deficiency with your policy or if that person has been retaliated against in the past, then that would be an excuse why they might not complain internally. They are required in Pennsylvania to file a charge with the Pennsylvania Human Relations Commission and or the Equal Employment Opportunity Commission, depending on whether or not they're pursuing a state or federal case. I think Dave would probably agree. In Pennsylvania, everybody goes federal. It's very rare that you're going to have a state case because the statutes are analyzed exactly the same way, And the way the damages are apportioned, it's to the plaintiff's benefit if they bring both claims in one lawsuit and the jury makes the award and then the judge distributes it. And this is maybe more than we need to know, but punitive damages are unavailable entirely under the state statute. They are available under the federal statute. The federal statute has a cap for damages. The state statute has no cap. So the judge, once the jury makes its decision, will figure out the best opportunity to allocate the money for the plaintiff, which is not so great if you're on the losing side. After the agency does an investigation, then they issue what's called a right to sue notice. Doesn't matter what they find, whether they think that there was harassment or wasn't harassment. It's basically getting your ticket punched, and after they get that right to sue, then the plaintiff can go to court. So this process that I just talked about can take from 2 to 5 years. The trial that we're going to mock today is a trial that I actually tried, not this past January, but the one before that involved claims that were about 4 years old. A year prior to that, I had another jury trial, also in Philadelphia, and that claim involved allegations that were 6 and 7 years old. So, you know, the lawsuit's very personal to the plaintiff, but imagine you're the person who's being accused of either not investigating or being the discriminator or the harasser or whatever. You live with that also for all that time. And you can see the cost, even for winning, may be, you know, $400,000 or $500,000.
And the damages clock is also ticking.
Right. Now, if you lose, to Dave's point, the plaintiff can get lost wages, both back pay and potentially future pay, in lieu of reinstatement, because most judges think reinstatement is probably not a good idea. You all pretty much hate each other at this point. Probably not great to put you back in the workforce. Emotional distress damages, punitive damages, not a harassment case, but an example of really big punitive damages was a case in New Jersey. It was an age case against Lockheed, I think. Now, I will tell you that the appellate division overturned the award, but it was the largest award, I think, in the history of New Jersey. It was like $55 million because the jurors believed that the management team was complicit in conspiring to fire this individual. So the jury awards can be pretty big. Attorney's fees. Even if the jury says, hey, you know what? I really feel for this plaintiff. I don't really think that this plaintiff is entitled to a lot of money, but I am going to give them like $1,000 because I want to, because you violated the act and that's what we want to show. Guess what? The employer is on the hook for all of those plaintiff's fees, like several $100,000. There can be court orders. Those are all sort of the hard costs. I hate the word soft costs because somehow it sounds like it doesn't matter, and in some ways I think they're more important, particularly in a social media society. People who are unhappy don't come to work. There's decreased morale. They do what I call employee equity, right? They take an extra long lunch. They need something. They take home materials from the supply room because, you know what? They owe me. I'm putting in a lot for this company, right? So when you have people who feel that they're being treated unfairly or harassed, and you have other people in your workplace who see it and feel like that the company's not taking a good care of those things, you'll see these types of things. And most importantly, now you're going to see it hashtagged all over the place. Somebody is going to post somewhere about what's happening and that you're not doing right by them and taking care of them. All right, so the trial we're going to do is called Veneer versus FNP Manufacturing. All the names have been changed from the actual trial. I'm going to play the role of judge. I'll give you a little bit. I'm so excited. I actually brought a robe. It's like my frustrated, like, you know, what I wanted to be when I grow up. It's not happening. And Samantha's going to play the plaintiff's counsel. They had an arm wrestle over who was going to be on the plaintiff's side. And Dave is going to be defense counsel. And it literally is scripted. So I really do need 4 volunteers. I need at least 1 woman, 2 women, and 2 men. So that would be great. Come on up. And I need 1 other person. All right, come on up. Thank you. I'm going to tell you a little bit about the case. And that you guys have your handouts, so I don't need to give them to you?
Yeah.
So give me just a moment here. So you are going to be our plaintiff, all right? So you're Joy Veneer. I'm going to tell you about Joy in a minute. You just read answer, and there's the direct is first and the cross is second. So we don't have enough chairs up here, but we'll put you up here in just a moment. All right, so Joy Veneer has been working at FMP Manufacturing for about, I forget, I think it's like 20 years. And you'll hear in opening statements that she transferred shifts to a later shift where she works for her alleged boyfriend. You will hear that the company has a conflict of interest policy where they need such relationships to be disclosed so that they can determine whether or not there is a conflict of interest and take appropriate action if there is. During the investigation, you will hear that Ms. Veneer raised the issue that the reason that she transferred was because she felt she was being harassed on the shift she was working. And specifically that one of her coworkers was leering at her and staring at her. And then you will hear that she and the supervisor who she was allegedly dating were both suspended pending the investigation. He was ultimately fired. She was reinstated but put back on the shift where she was originally working. She was given a last chance agreement because of her conduct. Well, the company says because of the conduct during the investigation. She says it was in retaliation for her complaints about harassment. And then she continued to work for the company and further then alleged various incidents of harassment, including visual and some physical harassment, which you'll hear about and you'll get to see. So just so you know, in the slides, they're actual trial exhibits. So I want you to envision, part of this is envisioning that it's your workplace and somebody went around taking pictures. And this is really what it's like in the courtroom. It gets blown up just like this, really big. Then she, of course, filed a lawsuit based on the company's alleged failure to address her harassment allegations and because they allegedly retaliated against her by suspending her during that investigation. So I want to thank Joy for being here. And then after Joy, we have Blair Jones, who is the plant manager. And if you would be Blair, anyone? Blair, thank you. And then Bill O'Connor is Ms. Veneer's direct supervisor. And this is the order the witnesses will go in. And last but not least, Beth Demig is the HR person. So what I think we should do is let's move the three chairs just over to the side. So when you're waiting to be called, they're like in the back room waiting to be called to the stand. And we'll make this the stand. And we'll put the plaintiff in the box early. So if you'd like to have a seat.
May I approach, Your Honor?
You may. And normally I would give you guys some jury instructions, but it sounds like you kind of know how this works. So you've all been impaneled to hear this case today. I ask that you listen with an open mind. And following the presentations of the case by the plaintiff and the defendant, I will give you some instructions on the law that you can use to apply to the facts. But it is your job to determine what happened and assess the credibility of the witnesses. And then after the trial, I will give you the law that you will then apply to those facts. Okay? All right, do you want me to sit here, or do you want to?
Doesn't matter.
Okay. And with that, do we have opening statements, counsel?
I do, Your Honor. Ladies and gentlemen of the jury, this case is very simple. The evidence will show that my client, Joy Veneer, has suffered egregious sexual harassment while working at FNP. And not only was nothing done about those complaints, but the evidence will show that Ms. Veneer has also suffered blatant retaliation. The evidence will show that my client first complained of sexual harassment regarding her first shift supervisor, Carl Smith, during an interview regarding an alleged relationship with my client and the third shift supervisor. You see, my client had recently transferred to third shift. When asked about this, my client unequivocally stated that Mr. Smith had been staring at her in a sexual manner. And how did FNP respond? The evidence will show that they moved her back to the first shift, reporting to Carl Smith, the supervisor about whom she had just complained. Then, a week later, she was suspended without pay pending investigation into her alleged relationship with Matt Giardello. Carl Smith, however, was never even asked about his behavior and was certainly never suspended. Upon my client's return to work, she was given a written warning. No response was provided regarding her sexual harassment complaint. From there, things only got worse. The evidence will show that my client was called a bitch on numerous occasions, that she had an open Penthouse magazine stuffed into her toolbox, and she was left breast-shaped candies in a box that read, "Bet you can eat just one." The evidence will show that Ms. Veneer complained of these incidents and even gave the magazine and candy to HR, and nothing was done. F&P is permeated with sexual harassment, and management and HR didn't even so much as interview a witness. My client was forced to work in this environment with no recourse and has suffered greatly as a result. I urge you to simply listen to the facts. They will speak for themselves. At the end of this trial, you will see that there is no other option but to fine for my client and hold F&P accountable for its actions. Strike that. It's inaction. Thank you.
Defense counsel?
Thank you, Your Honor. Good afternoon, members of the jury. I'm the attorney for FNP Manufacturing. The company is a long-established member of society and employer here in our local town. The facts will demonstrate that Ms. Veneer is unable to make her claim, and I ask that you listen to those facts and make a determination based on those facts. The facts will demonstrate that Ms. Veneer violated FNP's policy regarding conflict of interest. The facts will demonstrate that Ms. Veneer refused to cooperate with an FNP investigation as required regarding that potential conflict of interest. The evidence will also demonstrate that before these issues arose, Ms. Veneer had never complained about any offensive workplace conduct. The facts will demonstrate that Ms. Veneer was properly disciplined for her violation of policy, both of a failure to cooperate with the investigation and a violation of the conflict of interest policy. Moreover, the facts will demonstrate that Ms. Veneer continues to be an employee of FNP today. There will be no facts that demonstrate that there has been an adverse action. Instead, Ms. Veneer continues to work for the company and in fact has been promoted and earns more money now than she did previously before bringing these complaints. Ladies and gentlemen of the jury, those facts will demonstrate to you that she is unable to sustain a claim of a hostile work environment, disparate treatment based on sex, or retaliation. Thank you very much.
All right, counsel, call your first witness.
I call Joy Veneer, plaintiff. Good morning, Ms. Veneer.
Good morning.
When did you start working at F&P Manufacturing?
I've been employed there since 1994.
And what do you do there?
I'm a scheduler. I used to be a machinist. We make nuts and bolts and other fasteners for use in shipbuilding.
How many people work there?
Approximately 750.
Do you know how many women?
On the floor,
Yes.
57.
Does F&P have a policy against discrimination and harassment?
Sort of.
Does the company conduct training?
Not often.
You claim you have experienced sexual harassment while working at F&P. Can you please tell us about your experience?
Well, I complained to my boss, Bill O'Connor, that Carl Smith was staring at me. He looked at me suggestively, sexually. I asked Bill to move me off the shift that Carl worked so I could avoid him.
Did he move you?
Yes, to the third shift.
Did you experience anything else?
I've been called bitch. One guy asked me if my curtains match my drapes. Another guy asked why I wear such big shirts. He said he couldn't see my, sorry for the Catholic institution, my ass. I can't possibly name everything I've experienced. It's a bad place for women.
Did you complain about these things?
Yes, to HR.
When did you complain to HR about these things?
The summer of 2013.
Who did you complain to?
I met with Betsy and Blair Jones, plant manager.
What happened?
I was suspended.
For how long?
10 days.
As a result of being suspended, were you afraid to make further complaints?
Yes.
Did anything happen after September 2013?
Well, I didn't get as much overtime.
How much overtime did you miss?
I don't know. I can tell you that Bill stopped asking me.
Did you experience any further harassment?
There are sexual and offensive pictures everywhere.
Use this. We covered that. Yeah.
Okay. I'm going to hand you what's been marked Plaintiff's Exhibit 1. Is this one of the pictures that you found?
It is.
And did you take that picture?
Yes, I did.
I'll hand you Plaintiff's Exhibit 2. Is this one of the pictures you found at the workplace?
It is.
And did you take that picture?
I did.
I've handed you Plaintiff's Exhibit 3. Did you find that picture in the workplace?
Yes.
And Plaintiff's Exhibit 4.
Yes.
Aside from the pictures, what else? Was there anything else?
I found a pornographic magazine.
Where was it?
It was in my toolbox. It's disgusting.
What did you do about the magazine?
I took it to HR, to Betsy Demick.
What did she do?
Nothing.
Was there anything else?
I found a box of candies shaped like breasts.
I've handed you Plaintiff's Exhibits 5 and 6. Are these the candies?
They are.
Where did you find these?
In my toolbox.
Did you tell anyone?
I told Betsy.
What did she do?
Nothing.
No further questions, Your Honor.
Cross?
Thank you, Your Honor. Ms. Veneer, during the summer of 2013, you asked to move to third shift, right?
Yes.
And Matt Giardello was the third shift supervisor at the time, wasn't he?
Yes.
So when the company met with you in August of 2013, it was investigating your relationship with Mr. Giardello, correct?
I was interviewed, yes. I don't know why.
Okay. And in that interview, you were asked whether you had a romantic relationship with Mr. Giardello.
Okay.
And you refused to answer the question, didn't you?
It was none of the company's business.
Let me ask you, Ms. Veneer, are you familiar with the company's code of conduct?
I guess.
May I approach, Your Honor?
Yes.
So you have an exhibit marked as Defendant's Exhibit 1. Is this the code of conduct?
Yes.
And page 15 of the code of conduct contains the conflict of interest policy. You see that?
Yes.
And listed as example of actual or apparent conflict of interest, it says directly or indirectly hiring, promotion, or supervising a family member or a close friend. Did I read that correctly?
Yes.
Thank you. So if you were having a romantic relationship with Mr. Giardello and he was your supervisor, under this policy, that might be a conflict of interest, right?
I wouldn't know.
And Betsy Deming, the HR director, she asked you not once but twice whether you and Mr. Giardello were involved in a romantic relationship, didn't she?
I don't remember.
And the second time she asked you, you said, "No, I've been advised not to talk to you about this anymore."
Okay.
In fact, isn't it true that you and Mr. Giardello have been in a romantic relationship since 2008?
On again, off again.
In the summer of 2013, you were on again, weren't you?
I guess so.
So you lied to Ms. Deming when asked whether you and Mr. Giardello were involved, didn't you?
It was none of her business.
Regardless of whether or not it was any of her business, did you tell Ms. Deming the truth when she asked you?
No.
And because you didn't tell Ms. Deming the truth, you were issued a written warning, weren't you?
Yes.
And may I approach, Your Honor?
Yes.
I'll show you Defense Exhibit 2. Is this the written warning that you were provided?
Yes, it is.
By the way, what happened to Mr. Giardello?
He was fired.
And wasn't Mr. Giardello fired for lying to the company during the investigation into potential code of conduct violation?
I guess so.
And despite the fact that you lied during the investigation, the company still paid you a full week for the time you missed, correct?
Not right away.
Okay. And in fact, Bill offered you overtime the weekend you came back from your suspension, didn't he?
I don't remember.
But you turned it down.
I don't remember. I do remember that he didn't offer me overtime as much that fall.
And you hired your lawyer after you received the warning, right?
Yes, after I was retaliated against by being suspended.
And then after you hired the lawyer, you started taking pictures that you testified about earlier here, right?
Yes,
But you never complained to anyone at FNP Manufacturing about picture 1, did you?
no,
Or picture 2?
no,
Or picture 3?
no.
When you found the magazine in your toolbox, you knew it was a Penthouse, didn't you? It says it right here on the cover, correct?
Yes,
And you knew Penthouse was a pornographic magazine, didn't you?
yes.
So why did you open and look at it?
I didn't. It was open in my toolbox.
And when you found it, then you took it to Ms. Deming, right?
Yes,
The
that's
HR
what,
director.
yes, that's what I'm supposed to do.
But when Ms. Deming tried to ask you about it, you refused to talk to her.
She wasn't going to do anything about it anyway.
You didn't tell her where you found it.
No,
You didn't tell her when you found it.
nope,
You didn't tell her whether you thought someone specifically left it for you.
no,
You say you also reported the box of candies.
yes,
In fact, you handed them to Ms. Deming while she was walking by you on the floor, didn't you?
right,
You didn't, for example, take them down to Ms. Deming's office, right?
right,
Once again, you didn't give Ms. Deming information about the box.
no,
Okay. And you didn't tell her where you found it.
no,
You didn't tell her when you found it.
no,
You didn't tell her whether you thought someone specifically left it for you.
no,
You haven't reported any further incidents of harassment since the fall of 2013, have you?
no.
And let me switch gears a little bit now. What is your current position?
Production scheduler,
And when did you get that position?
fall of 2014.
Okay, so that is after your complaints of harassment in the fall of 2013, correct?
Yes,
And that job is a promotion from your previous job as a machinist, isn't it?
yes,
Okay. And it came with a pay raise and a shift differential, didn't it?
yes,
And you no longer work on the shop floor, do you?
right,
You work in an office,
right,
and you made $85,000 last year, didn't you?
yes,
And prior to your promotion, you only made $64,000.
I guess so.
So you made almost $20,000 less prior to your promotion, which came after your harassment allegations, right?
Right.
No further questions, Your Honor.
Counsel for plaintiff, any further witnesses?
No, Your Honor.
All right. We're going to forego the usual motions that happen here.
No recross either.
No, yeah. I can only script so much.
That's right.
Defense counsel?
We'd like to call Blair Jones, please, as our first witness, Your Honor.
Ms. Jones? We're foregoing the swearing in, too. You have a seat in the box.
Good afternoon, Blair. Do you mind if I call you Blair?
No, that's fine.
Okay. Who is your current employer?
FNP Manufacturing
Okay. And how long have you been employed by FNP?
for about 10 years.
And what's your current position?
I'm a general manager
And how long have you held that position?
for about 2 years.
And what was your position before then?
I was operation manager.
And what were your duties as the operations manager?
I oversaw all operations in a manufacturing plant.
Okay, and so what does that mean more specifically?
I had profit and loss responsibility for the manufacturing portion of the plant. Anything that went on a day-to-day basis and the overall achievement of performance
Goals.
to goals set forth by the leadership.
Okay, and do you know Ms. Joy Veneer?
Yes, I do.
And How do you know her?
She works for FNP.
Okay. And I'd like to show you what has been marked as Exhibit 1, the Code of Conduct. Is this FNP's Code of Conduct? May I approach again, Your Honor?
Yes.
Thank you. And has it been infected FNP since you worked there?
Yes.
I'd like to direct your attention to the conflict of interest section regarding conflicts of interest. Do you agree that it states directly or indirectly hiring, promoting, or supervising a family member or close friend is considered a conflict of interest?
Yes.
And do you agree that it states that it is a conflict of interest to allow personal relationships to conflict with an employee's FNP responsibilities or to compromise company interests?
Yes.
And do you agree that the Code of Conduct states that failing to cooperate in an investigation conducted by FNP could result in termination?
Yes.
Do you agree that the Code of Conduct also states that violations of the letter and spirit of FM policies are subject to discipline up to and including termination?
Yes.
Thank you. In August of 2013, did you become aware that Joy Veneer and Matt Giardello may have been engaged in a romantic relationship?
Yes.
And why did FNP care about that?
It came to my attention that Ms. Veneer had begun working on third shift in July of 2013. Matt was the third shift manager, so when I found out that they were possibly engaged in a romantic relationship, I was concerned that there may have been a conflict of interest, so I got HR involved and we started an investigation.
Okay. And who made you aware that Joy and Matt were engaged in a relationship?
Quite a few people, but specifically, I remember another supervisor mentioning it to me because he was concerned about her shift change.
Was Ms. Veneer still working on the third shift when the investigation began?
No, we needed to take her off that shift until the investigation was completed.
Okay. And did you meet with Ms. Veneer in connection with the investigation?
Yes, several times. The first time I met with her and Mr. O'Connor the day after I instructed that she be returned to the first shift.
And do you recall when that meeting was?
Yes, it was probably around August 15, 2013.
And what happened at that meeting?
Judy was asked why she was being taken off third shift. So then I handed her a copy of the Code of Conduct and directed her attention to the conflict of interest section. I asked her if she was aware of any potential conflict. She stated that there wasn't. So I then specifically asked about her relationship with Matt Giardello. She told me that it was none of my business. At this point, her voice was raised and she appeared quite agitated.
Did she mention anything else?
Yes. She then pointed out that I had dinner with Mr. O'Connor and his wife on one occasion. She then raised the issue of Carl Smith staring at her.
Had she ever mentioned this issue to you before?
No.
And what did you do at this point?
I knew we needed to start a second investigation with HR into this other issue, but we still had to determine whether there was a conflict with her working on third shift. So I told her that we would schedule another meeting when Betsy was available, and I asked her to take the Code of Conduct with her.
Did you meet with anyone else before meeting with Joy for the second time?
Yes. We met with Bill O'Connor and Matt. Bill confirmed that he believed Joy and Matt were a couple, but Matt started to deny it.
And what happened at the second meeting with Joy and Betsy?
At that meeting, Joy denied that she was in a romantic relationship with Matt, and then told us that she had been advised not to talk about that anymore. She then reiterated her complaints about Carl Smith and the staring.
Did she say anything else?
She also briefly mentioned some other issues she had, but told Betsy that she wasn't talking about that. She was only talking about Carl and the staring and harassment she thought she was getting from him.
Did she specify anything else about Carl aside from the staring?
No.
And where did the investigation go from there?
At some point, someone thought that Joy and Matt may have lived together, so went through their personnel file to determine if that was the case. I actually found documentation that demonstrated that Matt had made Joy his emergency contact and life insurance beneficiary. The investigation now took on two concerns: whether there was a conflict, but also whether there was a separate code of conduct violation because both of these employees were possibly lying during an investigation.
And regarding the emergency contact and the life beneficiary forms, did you confront them with those forms?
Yes. Upon finding the forms, we decided to suspend both of them pending the results of the investigation. And at each of their separate meetings, I showed them the forms. Mr. Girardello finally confessed that they had been involved in a relationship and later conceded that it would not be a good idea for him to supervise Joy. Joy said nothing.
All right, and what was the result of the investigation?
Because Matt was a superior, he was terminated following the suspension. He was not paid for the suspension. Joy was paid for her time off and given a written warning that highlighted the fact that she denied the fact that she was in a relationship with Matt during the investigation, despite the fact that she was.
And did you have any further involvement with Joy's accusations against Carl?
No.
That's all the questions I have. Thank you very much.
Cross?
Yes, Your Honor. Good afternoon, Ms. Jones. Ms. Veneer complained to you about being harassed, correct?
She said another employee was staring at her.
But she used the word harassed, right?
Yes.
And a week after she makes this complaint, you suspend her employment, correct?
She was paid for that suspension.
Not at the time, though, right?
Correct.
You then issued her a written warning that went into her permanent file, correct?
That is correct, for violating the code of conduct.
Ms. Veneer was no longer working on the third shift at that point, correct?
That is correct.
Even though Mr. Girardello was no longer managing third shift, Ms. Veneer was returned to the first shift, correct?
Yes.
With Carl Smith, whom she had just complained was harassing her, right?
Yes.
Nothing further, Your Honor.
You may step down. Your next witness,
The defense would like to call Bill O'Connor.
Mr. O'Connor. Do you swear to read the script to the best of your ability?
So help me God.
You notice we refrain from objections as well.
Mr. O'Connor, is it okay if I call you Bill?
Sure.
Who is your current employer?
FNP Manufacturing.
And how long have you been employed by FNP?
About 38 years.
And what is your current position at FNP?
Operations manager
Okay, and how long have you held that position?
for about a year, maybe 10 months.
And prior to that, what was your position?
Area manager
And how long do you hold that position?
for quite a few years, about 8 or 9.
Okay, so back in 2013, you were in the role as area manager.
Yes.
As area manager, what were your job duties?
My job duties were similar to my duties as an operations manager. I supervised several departments and oversaw the budget, stuff like that.
And what shift did you work on as the area manager?
Mostly first shift, but it's not like I punch a clock. I was there for more than 8 hours at a time.
Okay, and do you know the plaintiff, Ms. Joy Veneer?
I do.
And how do you know her?
I work with her.
And when did you begin working with her?
I met her probably 20 years ago. I've known her for a long time.
And have you worked together that whole time in the same department?
No, I didn't start working with her until about 2008.
And how did you come to start working with her at that time?
Joy was looking to switch from third shift to first shift, and I had an opening for her, so she came to work on first shift.
And were you Joy's supervisor at this time?
Yes,
And were you and Joy friends during this time?
sure. We had some mutual friends. We went out to dinner together as a group, maybe once or twice a year, but she stopped being friendly with me after Matt got fired.
Okay, we'll get to Matt in a minute. First, did Joy ever make any complaints to you about Carl Smith when she started working for you?
When she started, no. She didn't complain to me about him.
Did she ever complain to you about Carl Smith?
Yeah, at some point she complained that he was staring at her,
Staring. Could you be more specific?
just that he was looking at her. She didn't say anything else about it.
Did she say that the looks were sexual?
No,
Did she say that they were making her uncomfortable?
no.
Have other people complained to you about Carl staring at them?
Yeah, he's a tall guy, and he just kind of stares over the machines at everyone.
Did you do anything in response to her complaint?
No, I told her if she thought there was more of an issue, she should go downstairs to HR.
Do you recall when this was?
Probably June of 2013.
And in July of 2013, did Ms. Veneer request to go to the third shift?
Sort of. During a conversation when I was looking to try to shift some work to third shift, she said she would like to try it and see how the third shift schedule works for her kids.
During this conversation, did she say anything about Carl Smith?
No.
Did she ever indicate that she wanted to switch shifts to get away from Carl Smith?
No. She said she just wanted to try it for a couple weeks, see how it worked out with her home life.
And at some point after Ms. Veneer moved to third shift, did you have a conversation with Blair Jones about her move?
Yes. Blair called me and told me that Joy had to go back to first shift. She wasn't allowed to work on third shift anymore.
Did you tell Joy?
Yes.
How did she react?
She got real angry. She wanted to meet with Blair.
Did the three of you meet?
Yes, we did.
And do you recall when this occurred?
August 15th, 2013.
And how did that meeting go?
There was a lot of hollering back and forth. I was really just a third wheel. I didn't say anything. Joy wanted to know what was going on, so Blair told her that they were investigating her relationship with Matt because there are these rules of conduct and everything, and he gave her a copy of the code of conduct. She yelled that it was none of his business and about her relationship was what it was with Matt. Then she was yelling at him and that he had dinner with me and my wife.
Did she say that Carl Smith was harassing her at that meeting?
If she did, I don't remember it.
And after that meeting, Ms. Veneer went back to working on the first shift, is that correct?
Yes.
And did you have any subsequent meetings with anyone from Human Resources or Blair Jones?
Yeah, I met with Pam from HR and Blair again the next day.
What did you discuss at that meeting?
I guess they were doing an investigation into Matt and Joy's relationship. So they asked me about that, and I told them that I did think that Matt and Joy were a couple. I also explained that I had been discussing the fact that I needed additional employees on third shift, and that Joy was one of the volunteers.
Did you ever discuss the investigation with Matt Giardello?
Yeah, just one time, though.
What did he say to you?
He said, "I just wish the effing bitch hadn't lied."
Was he talking about Ms. Veneer?
I believe so.
And at this point, did you understand that there was a code of conduct with a conflict of interest at FNP?
Yes.
And in 2013, 2014, were you responsible for assigning overtime?
Not really. The team leaders did that. I had some input.
Did you ever limit Ms. Veneer's ability to work overtime hours?
No. In fact, she was offered overtime in other areas, but she would decline that overtime.
Bill, have you received any training on anti-harassment, anti-discrimination, or anti-retaliation policies?
Yeah, some. I took an hour course or two, but I don't remember when.
Was it common knowledge that plaintiff and Matt Giardello were in a long-term relationship?
I think so. They went on vacation together. We also saw them together at parties over the years.
And did Joy ever complain to you about anything else?
No.
She never complained to you about a pornographic magazine?
No, but I heard about it.
What did you hear about that?
Someone who's retired left a pornographic magazine in a toolbox, and Joy found it there.
Did you know what she did with it?
Yes, she brought it down to Human Resources, and they looked into it.
Bill, I'm going to show you a picture of what's been marked as P7. Did Ms. Veneer ever complain to you about this item?
No. Again, I heard about it when she complained to HR about it.
Did you do anything after these items were brought to your attention by HR?
Yes, I asked my team lead to do a sweep of the area to make sure that there were no other materials like that in the area.
And did he find anything?
No.
I'm going to show you a series of pictures that have been marked.
It's these.
These pictures back here. Sorry. Did Joy ever complain to you about those pictures?
No, she never brought them to my attention.
Have you seen them in the workplace before this case began?
No.
Are any of these pictures still up at FMP?
The ones that I could find, they're not there anymore.
And does Ms. Veneer still work for you?
No, she obtained a promotion in October of 2014.
Thank you very much, Bill. I appreciate it. No further questions.
Cross-examination?
Good afternoon, Mr. O'Connor. You testified at your deposition that managers at F&P are not trained on anti-discrimination policies, correct?
No, they're not.
And you also testified that managers are not trained on anti-harassment or anti-retaliation policies, right?
I did.
Prior to your deposition, you did not recall reading F&P's equal employment opportunity policy either, correct?
Yes, that's correct.
Prior to your deposition, you did not recall reading F&P's sexual harassment policy, correct?
That's correct.
You acknowledge that as a manager, it's important for you to be familiar with these policies, right?
Yeah.
You also don't believe people should come to you with complaints of discrimination or harassment, right?
No, they should go to HR.
Joy Veneer came to you with a complaint, correct?
Well, sort of.
She complained to you about Carl Smith,
Yes.
and you didn't do anything about it, did you?
I told her to go to HR.
But you yourself didn't ask her any questions about her complaint, right?
No.
You didn't do any investigation?
No.
You didn't go to Human Resources yourself?
No.
Carl also reported to you when my client made these complaints to you, correct?
Yes, he did.
And you permitted Ms. Veneer to be switched to third shift in July of 2013, correct?
Yes.
You testified that you believed Ms. Veneer and Mr. Giardello to be a couple at the time, correct?
Yes.
You didn't approach HR or any other manager to say that you didn't think they should work together, correct?
No, I didn't.
And I'm going to show you the pictures here behind me. Mr. O'Connor, this sign that's stating sexual preference is often was on display directly outside your office, correct?
Yes.
And this sign saying that I'm not a bitch, I've just been in a bad mood for 30 years was also on display directly outside your office, correct?
Yes.
And you did absolutely nothing about these signs until they were brought to your attention in this litigation, correct?
Yes.
Nothing further.
And defense, a final witness?
Final witness, call the HR Director, Betsy Deming. Good afternoon. Ms. Deming, who do you work for?
FNP Manufacturing,
And what's your job there?
HR Director,
And how long have you worked there?
4 years.
In your capacity as HR Director, do you have any responsibility over enforcing company's policies?
Yes, I'm responsible for enforcing the company's HR policies, including the discrimination and harassment policy, as well as the investigating complaints.
Okay. And do you have any special training that assists you in performing those duties?
Yes, I studied HR in college and have my SHRM license. I've taken courses at Temple on how to conduct an effective investigation.
Okay. And do you know the plaintiff, Ms. Veneer?
Yes, she works at FNP.
And did you ever receive any complaints about Ms. Veneer?
Yes, a couple of employees complained about Ms. Veneer after she moved to third shift.
And what did they complain about?
They said she and the third shift supervisor, Matt Giardello, were having an affair and that they would disappear into his office during the shift.
Did you investigate those complaints?
They said, I'm sorry. Yes.
Okay. And please briefly describe the steps you took to investigate.
Blair, the plant manager, and I interviewed Mr. Giardello and Ms. Veneer
And what was the purpose of the investigation?
to determine whether there was a violation of the company's code of conduct.
What kind of violation?
The code of conduct states that there may be a conflict of interest where a supervisor supervises a family member or a close friend.
Okay. And what happened when you interviewed Mr. Giardello?
He denied having a relationship with Ms. Veneer.
And what happened when you interviewed Ms. Veneer?
She also denied the relationship and told me it was none of my business.
Did that end the investigation?
No. Blair discovered that Mr. Giardello had identified Ms. Veneer as his emergency contact and his life insurance beneficiary.
What happened as a result of learning that information?
We interviewed Ms. Veneer a second time. She was uncooperative. We suspended both she and Mr. Giardello in order to complete the investigation.
Okay. And did Ms. Veneer raise any concerns during your interview with her?
She told me that she moved to third shift because she didn't like Carl Smith staring at her. She also alluded to other quote-unquote harassing conduct, but refused to give me any additional details or information that would allow me to investigate further.
And how did you complete the investigation?
We determined that they both violated the code of conduct by lying during the investigation and terminated Mr. Giardello's employment. Ms. Veneer was issued a warning and paid for the time she was suspended.
Did Ms. Veneer make any other complaints at any time to you?
She brought me a magazine and a box of candies, but refused to provide any additional information or details that would allow me to investigate further.
Thank you very much. No
And-
further questions.
Thank you. Finally, Cross?
Ms. Deming, you're responsible for ensuring the workplace is free from discrimination and harassment, aren't you?
Yes, that's one of my responsibilities.
And for investigating complaints of harassment?
Yes,
Now, my client came to you not once, not twice, but 3 times with complaints of harassment. Isn't that right?
yes.
But you failed to investigate those complaints, didn't you?
She didn't give me any information to allow me to investigate.
You didn't interview a single witness, did you?
I tried to interview Ms. Veneer, but she wouldn't cooperate.
You didn't interview anyone else, though, did you?
No,
You didn't take any steps to determine who placed the magazine or box of candies in her toolbox?
I couldn't. There were no identifying names or information on them.
You didn't, for example, interview her coworkers who would have been working in the proximity of Ms. Veneer's toolbox?
I didn't.
You didn't take any steps to prevent it from happening again, did you?
I'm not sure what you mean.
You didn't, for example, conduct any training for the employees about what constitutes harassment in the workplace, did you?
We did training for the supervisors.
But not for the employees?
No,
You didn't reissue the policy against harassment to the employees, did you?
no,
So again, you didn't take any steps to prevent the harassment from continuing, did you?
I didn't receive any more complaints from Ms. Veneer.
Have you looked at the pictures we've been discussing today?
I've seen them.
Would you agree that a reasonable woman would find these offensive?
Yes to some, no to some.
You would agree that none of these are appropriate for the workplace, wouldn't you?
I suppose not.
Ms. Veneer first raised her complaints of harassment to you in August 2013, correct?
Yes.
And at the end of the meeting, you suspended her, didn't you?
She was suspended pending the investigation into the code of conduct violation.
But she was suspended at the end of the meeting in which she complained about harassment, wasn't she?
Yes.
Nothing further, Your Honor.
Okay. Any further witnesses?
No, Your Honor.
Does the defense rest?
We do, Your Honor.
All right. So normally at this point in the proceeding, there would be closing argument, there would be jury instructions. We don't have time for all of that, so we'll condense that. Let me first thank our
Thank you.
witnesses for coming up. You guys can leave your scripts up here. So I have a question for you, Dave, really, because normally we go in. Do you want to take a break and then come back?
Whatever you want to do, yeah. Or if you want to talk, do you want to talk about this and
Do you want to take 2 minutes and talk about the trial, and then
Take a
then
break?
you have 2 other folks that are going to speak to you, and then at the end we can have more questions. Does that work for you guys? I mean, we've been sitting a little longer. Okay. So first of all, how many people would fine for the plaintiff? Nobody. Couple? No, we have sort of. Come on, it's okay. They can't see you. They only video us. It's fine. Couple of you. How many people would fine for the company? How many people didn't raise their hand?
Many people are not sure.
Yeah.
All right. So if you don't mind, I'm curious. So those of you who would have found for Ms. Veneer, what were the facts that made you make that decision? I had to tell you, you guys are great. All the comments that you made. So all I can tell you is that the case resolved in the middle of trial. So I can't tell you more details about that. I can tell you that my client was happy with the resolution. So that much I can tell you. But we got to talk to the jury afterwards, and it was really interesting because a lot of the comments you guys echo, and we cut a bunch of stuff because this trial was like a week long. We didn't show you the pornographic magazine because, we thought maybe that would be okay. There were a couple other things that we kind of cut to make it kind of fit, although we did run a little long. But the comments that you're making are parallel what the jurors were saying, and they picked up, just like you guys have, on all the different factors. Like, this is one of those cases where nobody did everything right, which is usually the cases that end up at trial. She was not a great plaintiff. She was not blameless. She was not a pleasant person. And from my perspective, I can say this. Once she was investigated, she wasn't happy about the investigation. Did everybody remember the Brady Bunch and the Greg lives by exact words episode? Do you guys remember that? So he gets into trouble, and he's like, and his dad's like, you're in trouble. Mr. Brady says you're in trouble, and Greg says, well, that's not what you told me. And he said, well, that's what I meant. And he said, well, that's not your exact words. And then for the rest of the episode, Greg has to live by exact words, right? And so in this case, my feeling is that she was like, fine, if you're going to be such a stickler about this policy, then I'm going to make sure you're a stickler about all of those other things. All of that said, none of that stuff should have been in the workplace. And it was really difficult to have witnesses on the stand go, yeah. And for the managers to say, oh, yeah, it was right outside my, I mean, some of that testimony is true. I mean, it's accurate from the, oh, yeah, I walk by every day. It didn't bother me. Like, this was one of the things that, there was another manager who said, well, it didn't bother me. I shouldn't have had to do anything about it. So, and I'm happy to talk more about the actual trial later, but I'm going to suggest we take a break, because then Dave is actually going to spend a little time talking about how to prevent that. And then we have our guest from Exude who's going to talk about it from the HR perspective. So if that works for you, Nan.
Good afternoon, folks. Now we'd like to get started for the second half of our presentation with attorney Dave Hackett, followed by Allison DeFlorio, the managing partner of Human Capital Management of Exude, and she has been the co-founder of that division since 2006. So we're going to start first with Dave. We're going to move on to Allison, and then we'll take questions. So I'll be walking around to collect questions. Just raise the card up in the air, and I'll be happy to make sure that the panel answers that. Dave?
Thanks, Danielle. Appreciate it.
Yep, thank you.
Thank you. Good afternoon, everybody. I'm Dave Hackett. I'm a labor and employment attorney at Cozen O'Connor. Happy to be here with you guys today. As Lori and Samantha mentioned earlier, we've seen a huge spike in claims that have been existed at the EEOC since the Me Too movement. And I can tell you that I've seen it in a number of different forms from the employer's perspective, my colleagues and I. We've seen issues arise that people bring up complaints about improper treatment that occurred 10 years ago. And you say, well, why did you wait so long? Well, they now feel emboldened that these other people are coming forward, and they now feel comfortable coming and complaining about the issue. Now, that may not be actionable because you have to bring a claim within 300 days for a Title VII claim from when the action actually occurred, but it's still something that as an employer that you need to investigate and address and take care of in the workplace. I've seen other instances where people, have said they just feel more emboldened that people have, engaged in sort of these banter or sexually offensive comments and made it, but now they finally feel emboldened that they're coming forward and they want to say something and have it addressed and have it stopped. So it's something that that we are seeing more of, and I could talk a little bit about it more, but I also, a lot of these things, some of them are, it's a combination of some of these most egregious things you see are just really offensive exercise of power and using that power for sexual benefits. And it's really something that shouldn't be tolerated in the workplace. We want everyone to be able to succeed and work in the workplace and have the opportunity to advance their career without having to endure or overcome these issues that exist in the workplace. And that's the reason that this statute exists. And I think some of the statistics that Lori pointed out, there was also an article in the Wall Street Journal, the fact that 88% of women feel that they've experienced sexual harassment in the workplace. And as I've talked to people, I'm like, I can't believe that to be, I had the same reaction that her colleagues had. I can't believe that it's that much of a statistic. But as I spoke with other women, they said, oh yeah, there's not, I've talked to some, I talked to Rosemary Connors from NBC 10. She says there's not one woman in the, who works in a newsroom that hasn't experienced some form of sexual harassment, not anywhere. And colleagues that I work with as attorneys, and that's a shame, and that's something that we need to ensure changes, and people are now exercising their rights under the law to ensure that it doesn't exist. So what are the things that you need to do to make sure that harassment doesn't exist and is addressed in the workplace that the employer needs to do? So first of all is the 5 R's. The employees need to refrain from engaging in sexual harassment. If there is sexual harassment or any offensive conduct that needs to be reported, the employer then needs to respond to that complaint and needs to investigate it and conduct a thorough investigation and address it. Then is to come up with a remedy, to make a determination. What, did something happen or did something not happen? Was the policy violated? And if so, what is the right remedy to, one, address that issue, and two, make sure that it doesn't occur again in the workplace? And finally, also to make sure that there is no retaliation. And how are you going to do that to make sure that this person is not then retaliated against, whether the complaint was founded or unfounded, that person is not retaliated against because they did feel comfortable enough to come to HR. And to go back to the fourth one for the remedy, you want to be, if there is a remedy that needs some action that needs to be taken, that remedy cannot be an adverse treatment of the person who complained. So let's say you worked on, they both work on first shift, and her supervisor, a woman is harassed by her supervisor. It's not going to be a satisfactory remedy for that female employee to be moved to third shift. What? I'm at 9 to 5 and now I'm working midnight shift. That doesn't work for me. How's that, giving me the remedy? That's not going to be a valid remedy in that situation. You want to make sure that there's no adverse action that employee is suffering as a result of a complaint that's found to be justified. Yeah. And focusing on the workplace has got to be just as important as your bottom line. It's key to your productivity. It's key to avoiding liability. Those are the things that you need to think about in your workplace, and having the right policies in place and making sure, as I've talked to some folks about today, that your supervisors are on the front line, are the ones that are aware of the policy, have their eyes open, and are addressing issues that they become aware of in the workplace. Why is it important? It's important for your company culture. People are going to, it's important for morale and productivity, that people feel that they can succeed in the workplace, and people get along well and are not intimidated in the workplace. It's a workplace of respect where people feel coming to work that they enjoy and they want to move forward, and you want to comply with the law. You want to avoid liability. And in the new day dawning, those threats of potential liability exist even more and more. And what is considered to be tolerable in the workplace, or what may have been considered tolerable or was not tolerable but people just simply went along with, is no longer going to be the case, has been evidenced by the increase in claims. So that's why it's important to make sure that as an employer, you're redoubling your efforts to have a policy that you're enforcing, that your employees know about, and that they know that they have an avenue of what to do if they complain. I think we'll go through this a little bit later, but your policy needs to have, as I think Lori did mention this, different avenues in order to respond to the complaint. So your complaint should say, if you have a complaint, if you feel that there's a violation of this policy, you should report it to your supervisor. If you feel uncomfortable reporting it to your supervisor, then you should go to the human resources director. A lot of companies now also have anonymous 1-800 lines that you can call in order to report a violation. And that's something that's a very good idea. So a lot of that is based on laws for ethics compliance, but it also goes for anything else that can be a wrongful thing that exists in the workplace, and it's an avenue for them to be able to address an issue. We spend the majority of our waking hours at the workplace. It's your comfort zone, and friends and family send pictures and jokes, and so the key is making sure that your employees establish and know and give them examples of what is acceptable and what is not acceptable conduct, what steps over that line, and to create a professional environment where people are friendly and interact with each other, but don't step over that line in their interactions with one another, to create something where someone feels uncomfortable, is offended in any way, and that really needs to be something that you need to teach your employees of. They need to be cognizant of. It's not what you think is offensive, but it is how that person may feel when they receive your when they hear what you say or respond to what you do. How would a reasonable person and that subjective person feel with such a statement? Not that you're offended by it, but how would they feel, and put themselves in their shoes. So here's a true or false question. Can your company be liable for the sexually harassing behavior of an outside vendor, even though the vendor is not an employee of the company? How many people say that that's true? Any people think it's false? Correct, it's true. So that even if you are, let's say you have an outside vendor, you have a client that who is responsible for a lot of business for your company, and you're going out to dinner to celebrate a big new contract. If that vendor is harassing, let's say he is harassing a female employee on your staff, or being offensive, telling jokes, touching, any of those things, those are things that are going to be potential issues for you, and that could create potential liability, particularly if you're aware of it and if she complains about it. Those are things that you want to address and make sure that don't occur in the workplace. It is not illegal if a woman sexually harasses a man. True or false? You can say it out loud. False. That's correct. It can be. It goes for all ways. If you treat someone differently, harassment can be. And let's do the next one. So it is not illegal if a man sexually harasses another man, or if a woman sexually harasses another woman. Is that true or false? False, correct. So any way you treat somebody differently because of their sex, that's going to create liability. And more now, more courts are also interpreting sex to go beyond male or female to be sexual orientation. So even if it's not explicitly in a statute, there are courts now that have extended beyond what the Supreme Court has currently said, but are extending that to go beyond, to read sexual orientation into the statute. So that's something that you need to be cognizant of in the workplace as well. True or false, sexually harassing behavior by one employee towards another that occurs outside the office is still within the responsibility of the company and its managers. True, that's right. So you're out, even if you're at a Christmas party off property, if you are on a business trip, even if there was an issue that people were at couples got together and had their own party on a Saturday night, and some conduct created there, and that employee now comes in and complains about the conduct that occurred over the weekend, that's something that you as an employer need to address, of the potential impact that could have in the workplace. You must actually touch or say something sexual to an employee in order to commit sexual harassment. True or false? False, correct. So anything could be pictures that are up around the workplace, things that are on a screen, even they see as they're walking by, that are on your computer, that create an atmosphere that makes that employee feel uncomfortable and that they're offended by, can be an issue that create a sexual harassment issue. Under the law, only a supervisor can engage in unlawful sexual harassment. I think Lori already addressed that answer is false. That can be your coworkers, that can create an offensive environment, that can lead to liability. I'm going to just skip over these slides because Lori already addressed this to talk about what is sexual harassment, but I did want to give you one example of sort of making sure that you have the right policies in place. I'm just getting to my right slide here to make sure this is where I wanted to bring this up. It is. So I had a case one time with a convenience store. This is not a Wawa. This is not a Wawa, all right? So it was down in Delaware, and as evidence that it's not a Wawa, there are like no customers in the convenience store at the time. So there's no customers there. It's just the manager and the clerk. And the manager's male and the clerk is female. And the manager says, I'm going to go into the back storeroom, and when I come out, I'm not going to be wearing anything but my birthday suit, or not going to be wearing anything but a cigarette. And she's like, aha, very funny, you know. Well, he goes back in the storeroom, and he comes out only in his birthday suit with a cigarette. She screams, yells. He goes running back into the storeroom. She calls her husband, who comes and picks her up. She goes home. She looks in her employee handbook and sees a 1-800 number to call. She calls it. The regional manager comes down the next day. The guy admits it, and so they terminate the store manager. They give her some time off. So that's the evidence of, right, you've done everything correctly, right? There's nothing you could have, well, we'll get to that a little bit, but nothing you could have, employer gets put on notice of the offensive behavior, addresses the behavior immediately, the employee utilizes the policy and to address the offensive behavior, and the offensive behavior is remedied. So there's no liability in that situation, right? She then claims that she was given some time off. She comes back to work. She says, well, you know, people kept raising the issue, you know, about this incident, and it was too much for me to put up with, that I eventually resigned, and so I was constructively discharged from my job. Well, what we said was, well, you didn't call the 1-800 number that you used for his offensive conduct. You didn't use that or otherwise contact a manager to let them know that you were feeling offended by these reminders about this incident to address, and that eventually was successful in us in winning the case. Another fact that never came up in discovery of that case, which demonstrates something else that you employers should do, is that if this convenience store did not conduct criminal background checks, and if they had, they would have known that he had criminal convictions for indecent exposure, this store manager. So that could have been an issue of negligent supervision, negligent hiring, and would have created an issue for for this case overall if that fact had come out in the litigation. So let me skip through here a little bit. We talked a little bit about what are some types of examples of the severe and pervasive behavior. So it can be off-color jokes and teasing, foul language, comments about body parts, sex life or sexual prowess, you know, and so that's something where you have to be able to judge what somebody is what's appropriate and what you shouldn't be discussing with employees, what's appropriate for the workplace, and what type of comments would you make? If you made a comment about a female employee, would you make the same comment about a male employee? Would you say, you think you're being complimentary and you say to a woman like, oh, that you look so nice today, you know, that skirt really shows off your legs, you know, like, okay, was that really appropriate? You're trying to be complimentary, but is that really appropriate? You know, are you going to come up to Dave and say, Dave, that suit looks really good on you, it really shows off your guns, you know? Probably not going to happen. I need to work on my guns, but that's another whole issue. But, you know, those are the type of things where you need to, you know, is it the type of comments that you would make to a woman, the same type of comments that you would make to a man in the workplace, or what conduct? And there's certain, you have to have an understanding of what is welcome and what is unwelcome. You know, what is the tolerance level of a, you know, some guys are going to be able to joke around the cooler and know that conduct is acceptable to them. And you have, the employees need to make the judgments of what is acceptable and not acceptable based on the audience that they're experiencing. And you need to be able to take the cues from that. So does a person need to come out and say, you know, I am offended by that comment. Please do not ever make that comment again. They really don't. If they even just roll their eyes or they stop and turn and walk away, that is a cue that that person considers that conduct to be offensive and that needs to be a cue in your training of your employees that conduct is not tolerable and that they should be refraining in the future from engaging in such discussions, whatever they were engaging with that employee in the future. So, as Lori mentioned, repeated requests for dates, publicly posting suggestive pictures, offensive emails, touching, brushing, cornering someone. Is that the way that you would treat a male employee? Is that something you would do? Those are the type of things are going to be that, are you treating this employee differently because she is a woman and how you interact with her? And what is that employee considered to be offensive and unwelcome? Those are the things that need to be taken into consideration in the workplace. So the second type is a quid pro quo. If there's submission to a certain individual, submission or rejection to conduct, and that it's a quid pro quo. You need to do this in order for your employment. You need to come out with me, or I'm not going to give you better assignments. If you don't come with me, you'll go to a smaller cubicle. If you don't at least have one drink with your manager, you'll be fired. And these things may not be things that are explicit. Somebody may say, it was evident in the workplace that, people that flirted with Jim and allowed him to touch them and rub up against them, they got promoted in the workplace. And if you weren't into that, then you didn't get promoted and you were in the same position. That would be considered conduct that would be unacceptable and evidence of a hostile work environment. And evidence that if you didn't submit to them, that you weren't able to advance in your career. That would be something that would be actionable in the workplace. And the real issue that employers need to be cognizant of today is that it's not just 9 to 5. You are communicating with your employees all the time, and those issues can create liability issues. We now live on the internet. Computers of what we show, pictures that we send to other folks, texts that we send to other people, Instagram, whatever it is we do, now pervade our workplace and is more of an issue of what we have to govern and evaluate that can create potential liabilities to an employer. The thing that happens is text messages are the most revealing of your thoughts, right? Oh my God, you look great. Person is a manager, has a couple glasses of wine, and sends a message. Those are things that now are big mistakes and create a serious liability issue for the employer of how they're treating someone differently in the workplace based on their sex. And the workplace is everywhere. So there should be zero tolerance in the workplace. Oh, can you come here? I had a hard day. Come here and give me a massage. Nobody's asking the male employee, right, to come and give him a massage. Or, that just doesn't happen, right? And it shouldn't happen to any employee in the workplace, right? Friendly nicknames that sweetie, those type of things. Those should be things that are not utilized in the workplace. That things that can be interpreted by an employee as demeaning. Those are things that should not exist in the workplace. And any type of sort of touching, should be want to create a professional workplace and a professional environment for where everyone feels comfortable and is able to get their work done. But you can still have fun, you can still be friendly, you can still get work done, but you need to see that there's a line that you don't cross and that's not going to be tolerated in the workplace, and make that clear to your employees. And if they feel that it has been crossed, that they have an avenue to come and take care of it. So set the tone. Conduct yourself in a businesslike manner, consistent with professional norms and standards. How you act appropriately. understand the comfort zone, and managers need to understand their power and how they might be abusing it, that people react differently when you are in a position of power, and how your words might be felt and the impact that they're having on someone who reports to you, and that needs to be, supervisors need to be trained on that and be aware of that. And need to be aware of, as we talked about earlier, that a supervisor's knowledge can create liability, so they need to be alert for signs that any sexual harassment might be occurring in the workplace. Rough or foul language should not belong in the workplace. Employees should use discretion. Avoid personal relationships. So we talked about in the example that we had for our trial, right? We had the supervisor and the employee being supervised, working together. So why do companies have policies against that? One, because it can create an issue if the relationship goes bad, that now that person says that, it was a quid pro quo for sexual, that I had to, sleep with him in order to continue to working, and now I've been adversely treated. Now that the relationship's gone bad. That's one reason. The other reason is the message that it sends to the other employees that, in order to get treated well, in order for me to advance in the workplace, I need to sleep with the boss, basically. Those are the things that you want to avoid in the workplace, and set the tone on that those type of relationships are unacceptable. One thing, so this last one, consumption of excessive amounts of alcohol does not mix well with employment situations. This is something that we always get involved in for Christmas parties, right, is a big issue. So one thing that you need to do for that, if you are going to decide that you're going to have alcohol at an event, a company event, you want to have, I would have someone that is assigned for sort of supervising folks and making sure that people are conducting themselves appropriately. You also may want to have the event at a time that maybe a luncheon where alcohol is served, where people may not consume as much alcohol, or limit the amount of drinks that each person may have. Those may be some ways to avoid issues. But again, having someone overview just the scene generally. I have one person who gave me an example that they worked in a law firm previously where they had, everyone was aware that, the founding partner of the firm, they had to be on watch for him on the Christmas party. They had to have a limo ordered so that he didn't drive home, that he was ordered, and there was someone, basically a protector of the staff, like basically the watchdog, to sort of, if there was a conversation like, okay, let's move Fred along over here somewhere else, or interject in the conversation to make sure it wasn't going in the wrong direction. That's an unfortunate thing that to even have that existence, but at least they had something in place to try and mitigate against a potential liability and risk in those occasions. So it's absolutely an obligation for managers to act promptly and appropriately when presented with any behavior that constitutes harassment, and to contact human resources immediately. So as I mentioned, you should have a harassment policy. Your employees should be trained on that harassment policy. You should also then conduct investigations immediately if you do have a complaint. In conducting investigations, my recommendation is that you have 2 people in the room for the employer who are interviewing the witnesses, that it should be someone who is responsible for asking the questions and someone who is responsible for taking the notes largely. When I conduct investigations, I largely ask the questions. The associate is taking the notes, but the associate can also then pop in with any questions that he or she may have to add into anything that I may have missed. But largely, that's for conducting an independent investigation. Therefore, we're able to be witnesses who have a consistent story and are able to back each other up, rather than creating a he said, she said story with respect to the investigation and how our investigation was conducted and what statements were made by the people that we were, the witnesses that we were interviewing. And here's an example of, a policy that you could have written out of how it's forbidden in the workplace. Most people have an anti-discrimination policy that goes into outlining that unlawful harassment based on race, sex, age, color, any of those things is also unlawful, and then specifically goes into sexual harassment and outlining that and provides specifics with respect to what is acceptable and non-acceptable conduct in the workplace. And then a complaint procedure that exists to whom, in what form it should be made, and you also want to put in your policy to have an anti-retaliation policy. As we mentioned earlier, that can be a huge issue in the workplace of that, the tail that wags the dog, or any claim that we see today. If it's a sex claim coupled with a retaliation claim, it's an age claim coupled with a retaliation claim. So that's the issue, and sometimes the harder to defend. So having a policy in place, making sure that people are also required to report any feeling of retaliation, and having that available is key to have in your policies. I sort of went over this a little bit. I talked about the investigation. And you need to then, when you conducted an investigation, inform the witnesses that, listen, we're going to keep this investigation confidential as much as possible, but there may be some disclosure of facts that we need to make as part of the investigation. We ask that you keep this investigation confidential so that we're able to interview each witness and get the facts from them rather than there being a whisper down the lane, and rather than them knowing the questions that are asked coming in. For us to conduct a thorough investigation, we want you to be truthful and tell us everything that you know about the situation. To the extent you know something that I don't ask a question about, I ask that you relay that information to me as well, and that at the end of and then when you're talking with, those would be the things that I would talk about with every witness in an investigation, and then with both the accuser and the accused, you need to make a determination and then make a report back to that person at the end of your investigation regarding your determination, whether it's a founded or unfounded complaint, and if it is founded, what the discipline is going to be, and how we will proceed further in the workplace moving forward. And also to give the instruction to the employee that, particularly to the person who makes the complaint, to say, both at the beginning of the investigation and at the end of the investigation, that we don't tolerate retaliation, and if you feel in any way that you feel you're being retaliated against for making this complaint, that you should come back to us in the Human Resources Department to let us know that, and we will address that. So remember the 5 R's that we talked about at the beginning. That's the key for how to engage. Refrain from engaging in inappropriate behavior. Report all complaints to HR regardless of apparent merit, or if the employee does not, even if the employee says they don't want an investigation. They say, I've got this going on, but I don't do anything about it now. You know, that you can't do that. You can't sit on it. You want to make sure at least that HR is aware of it. Respond proactively to inappropriate behavior. And if you're a supervisor, you want to address it and say, this conduct can't go on. I want you to stop it, address it, say that, and then you also want to document it. You want to document that you've addressed it, and here's what you saw, and here's how you attempted to address it, and have that kept on file to be available. And then remedy for any appropriate behavior without putting any legal labels on it. You know, what is the remedy? How is the way that we're going to solve this problem moving forward? What's the appropriate discipline? And then don't retaliate. And that's it. And I will turn it over to Allison so we can keep going and hopefully have time for some questions that you may have.
should be.
Yep, it's one of these years.
It is that one.
This one.
And then I'm told to do F5,
F5.
and it's
There you go.
magic.
All right,
And
there
there
you
it is. Great. Well, I don't know about you, but it's good to hear all these attorneys giving us the advice that's going to help us protect our organizations. And sometimes I wish that some of the people that I speak to on a regular basis have the value of hearing that as well. My name is Allison DeFlorio. I lead the Human Capital Division of Exude. And I want to just tell you a little bit about my experience as it relates to this topic. So I have been in the human resources space for over 20 years. I started as being an in-house HR person in one of those top 5 industries that was named hospitality, which is a wonderful place to get examples of harassment, just in the nature of that. And I say that kiddingly, but not so kiddingly. About 12 years ago, I moved over to Exude, and my world in the last 12 years has been supporting organizations from all different kinds of industries in working through, proactively helping to put in HR infrastructures and processes and building culture to avoid having to deal with some of the things that we talked about today, and then also kind of talking them off the ledge and helping them work through some of the kinds of scenarios that you talked to today. So I'm not going to repeat some of the detailed policy things that you've already heard, but I am going to talk kind of holistically about as an organization, what can employers do to really create an environment of mutual respect, and what can employees do to make sure that you know your role in maintaining an organization of mutual respect. And I use that word mutual respect because in my experience, and I would imagine that our attorneys in the room feel the same way, many of the issues that rise to the level of harassment started as something small that somebody turned their eyes and didn't address. A manager casually said, that's just Joe. That's just Joe, just don't worry about it. He just does that all the time. Left unsaid, left unaddressed, that now becomes part of the culture of an organization. So, the world has changed. It is a different game. Back in the day when I started in human resources, we did our annual training. Everybody got it at orientation along with 900,000 other policies that they had to know and they were expected to remember, and that was it. That was it. It's not like that anymore. This has to be part of your culture. You have to create an environment that is mutually reinforcing so that people in your organization know what is expected of them regularly, that they hear it, that it's reinforced, and that your managers are well trained to uphold and execute effectively against the policies that you have set. So, in thinking about how best to share that with you today, I came up with, I will call, 5 tips that we're going to focus on. We're going to talk about being an awake leader. And I don't mean that just as a manager. Anyone can be a leader in an organization when faced with a situation like some of the things we talked about and what steps to take. We're going to talk about creating an intentional culture of respect. Cultures happen. You need to be intentional about the kind of culture you want to have in your organization. We're going to talk about bringing that culture to life through having mutually reinforcing processes and policy, training regularly, and then stand your ground. So I'll explain each of these as we move through. But first a question, how many of you watched 60 Minutes Sunday night? Yeah, okay. So we saw this guy, Mario Battelli, famous chef, somewhat of a bigger-than-life personality, and also a guest in a restaurant, Ken and April's restaurant, if you watch the whole episode, a frequent guest who just had egregious behaviors that were regularly overlooked. He wasn't an employee of that restaurant, but the servers repeatedly went to Ken, the owner, and April, the executive chef / owner of the Spotted Pig, and said, "He's grabbing my breasts when I take his order." "Oh, that's Mario, don't worry about it." This restaurant, by the way, was known for having celebrities. That was a big thing. You would see celebrity chefs there. You'd see celebrities there. So they didn't want to do anything with Mario, okay? They didn't want to do anything. Think about your organizations or organizations that you work with. Is the person who's demonstrating these behaviors the rainmaker, the one that's got all the relationships, the one that we say, no, just look the other way because we can't afford to lose him? I'm going to suggest to you that no one is above being addressed or being removed for egregious behavior. And in my experience, by saying nothing, you're giving tacit approval that the behavior is okay. So I don't care what policies you have in place, and I don't care what training you've done. If that behavior is allowed, and you are the leader or the manager or the supervisor, and you see it, and you're told about it, and you do nothing about it, then you're going to be talking to one of the lawyers in the room, okay? Or you're going to be in one of those court cases. So when I say, and this is not an example of awake leaders, we define awake leaders that have their ear to the ground, that listen to employees, that take their complaints seriously, that follow their processes to investigate, to fully understand what is going on here, and then take appropriate actions. They acknowledge what is happening. They don't look the other way. They don't say, I don't have time to deal with that right now. I have to run a restaurant. I have to manage this. I have to do that. They actually take the time and say, this is important and I'll address that, and take immediate action to resolve. They are not the ones that give tacit approval by saying nothing, okay? So being an awake leader in your organization is critical. I have to say, something that David was talking about, one of your questions was, can vendors, if it's a vendor, then are they immune from, it's not harassment. I have to share an experience back from my hotel days of an awake leader that I worked with. At this particular time, I worked for a very large convention hotel. Hotels make their money by putting heads in beds, right? So rooms are really important. And we had a group in, and this group was responsible for probably 3,000 to 4,000 room nights every year. Annual contract, very big group, very important to the business. On this particular occasion, the leader of the group, notoriously difficult. But in this particular occasion, in human resources, we had a room service person come in and say, hey, this is going on. And then the housekeeper went to the housekeeping manager and said, this gentleman, the head of the group, did this to me. Fortunately, there was great training in place. There were great processes in place. Housekeeping manager let HR know. They put 2 and 2 together. And the general manager at the time took immediate, swift action. Knowing at a risk that this gentleman could pull his group, he said to the man, this behavior is unacceptable. You will not treat my employees this way. You are no longer welcome at this hotel. Your members are, and they can stay, and we'll find you another hotel to stay in while you're here in Philadelphia. But we will not, you're no longer welcome here. That was a statement to the staff that supported the fact that we do not tolerate this kind of behavior. Okay, that is an awake leader. So the other thing that we want to talk about is it's about culture. What kind of culture do you have in your organization? I often, when I'm working with companies for the first time, I'll ask them, hey, give me 3 words to describe your culture. What kinds of words do you think I hear? What words would you use to describe your culture? Entrepreneurial. Any others? Supportive, and then I didn't hear the other one. Sorry. Free? Clarity? Collaborative. Yeah. Sometimes we hear things like, we're a culture of integrity. We're a culture of respect, right? Sometimes I'll hear people say, do you want me to tell you the culture I want to be or the culture we actually are? Okay? But think about that as employers. Ask, what culture are we really? How would people describe what it's like to work here? Because culture is really important. One of the previous presenters talked about don't bury your head in the sand, and I had a chuckle because I knew I had the slide here. You cannot allow your culture to evolve around you by burying your head in the sand and pretend that you don't see the things that are happening around you happen. If you're very clear and intentional about building a culture of respect, then you define what it is, You train all of your managers and your staff on upholding that, and your own actions and behaviors have to support that culture of respect, okay? So here's a little quiz for you. These are real core values. Some of our clients say, well, we have core values. That's our culture, right? These words on paper. And so these are someone's real core values. We're creative, problem solving, shape the world you want, welcoming for everyone. What company is that? What do you think? You all know this company. What? Disney? No. Who? Wawa? No. They truly are welcoming to everybody. It's Uber. Now, based on what you've seen in the news, have they been welcoming to everyone? No. In talking about sexual harassment, clearly not to the point that they're actually assaults and a culture of fear, of retaliation, and of silence. A code of silence, we don't talk about it. Now, I have to say, Travis is gone, new CEO is in, and they are trying to turn this ship around. But my point here is, your culture cannot be words on paper. It cannot be words on paper. It has to be part of everything that your employees feel and do, okay? It is as meaningless as a policy against harassment if it does not come alive and it is not supported and reinforced throughout an employee life cycle. So culture is part of that collective understanding of how things are going to be done in an organization, right? Some of it is spoken, some of it is unspoken. So it's really, really important that it be intentionally defined, proactively practiced, and launched by leadership. Leadership has to drive culture regularly. And there are some organizations that do a phenomenal job of that, and organizations that don't take it seriously. But culture is extremely important. So create an intentional culture, something to put in that culture. Think about how we practice responsible communication. We communicate effectively. We communicate when things are good, when things are bad. If you can have open communication in an organization, you're more likely to find out about issues and little buckets of disrespect before they become enormous problems. Infuse it through the entire life cycle of an employee experience, in your statement of anti-harassment, professional conduct. Share stories. It can't just be at orientation when they sign that. You have department meetings. You have opportunities when things like that story that we just talked about on 60 Minutes hits the news. If that's your industry, and I'm a department head, I might share that and say, I want to make very clear that this will not happen in our organization. That's a way to reinforce and make those words really, truly come alive. And then certainly lead by example. And here I mean, if indeed you have a culture of mutual respect, a culture of open communication, a culture of treating people with dignity, and somebody tells an inappropriate joke or takes an inappropriate action in a group setting, where do all the eyes go? Where do all the employees' eyes go? They go right to the manager or the supervisor. So you might have a more seasoned manager who knows that and is not going to react or will react appropriately and say, you know, Joe, that's enough. I can pick on Joe because I work with him. Joe, that's enough. That's not tolerated here. Or you might have a newer supervisor or manager who may not be as trained and may just have gone from being coworkers with these people to their supervisor and may laugh right along with them. I wouldn't want to be that employer when they're in court and that person is complaining about harassment when those kinds of things have happened. So make sure that you're really clear that you have to lead by example here and don't tolerate behaviors that aren't consistent with your culture. Next is to bring it to life through those policies and procedures. We heard a lot about what to include in your policies, and I'm not going to talk about that. What I am going to talk about is how you really want to make sure everything is mutually reinforcing to protect your organization and to protect your desired culture. So, policies are necessary because in the absence of direction, people make up their own stuff. Employees want to know what to do and who to go to and how to report. So policies are important. Just as important is having the procedure that supports it that occurs on a regular basis, okay? So when we think about one of the statistics you used, 66% of people don't know. Employees in your survey said that they didn't know that there was an anti-harassment policy, or they didn't know what it was. This stat from last year, the EEOC was saying that 70% of people don't report claims. That's an astounding number. Do you think that's an astounding number? I tested this out at a presentation a couple months ago on harassment. We had a group of about 100 in the room. And one of the panelists asked, oh, well, how many in this room would go to report something to Human Resources? Out of 100 people, and there were many young, I'd say like 25 to 35-year-old people there, only about 3 raised their hand. 3 raised their hand. When I asked the question, they said, well, they're not going to do anything about it anyway. Or I'm going to, if people find out I went to HR, I might get in trouble. Now, what does that tell you about the culture of those organizations? What do you think? That's not the kind of culture you want to have, right? So if you know that 70% may not report, to really be intentional about ensuring that nobody has a fear of retaliation, that you have a culture that you want to hear what's going on. The other thing they said in this report is that there was the bystander effect. So this is something we haven't talked about, but it's interesting. People not directly affected, but that see something going on and choose not to say anything because they say, well, those 3 people were there too. Let one of them say it or assume that they're going to say something about it. Or socially, they don't feel like they should do that that might be, workplace suicide if they say anything about it. One of the things I hope that you take from this is when you do training for anti-harassment, include bystander training. Include a statement about what bystanders who see things, even though it's not directly happening to them, going on in a workplace that is not consistent with your culture or with your policy, what can they do? What can they say? If it's a man saying something degrading to a woman, and that bystander is a man, how could you interject and say, hey, Joe, I heard how you talked to Allison in that meeting. I just want to let you know, I kind of found that offensive too. Give them words, give them phrasing, make them feel comfortable and confident in addressing behaviors that are not consistent with the policy as well. And then the masculine culture, with some of these male-dominated fields, like engineering or like technology companies, there just aren't a lot of women there, and so it kind of takes on its own culture. And that makes women in those environments uncomfortable about reporting. So if you run a company that's male-dominated, you want to be mindful that maybe the culture that got you to where you are today is not the culture that is going to help you get to where you need to be tomorrow. So you want to think of a culture that is inclusive of all of the people that you have. We see this sometimes with startups. Startups are so exciting, they grow, everybody's a lot of camaraderie, but then you start bringing in people that may be different from the people that started the company. And maybe their perceptions of how behaviors are received are different. So you really have to think about this with a very inclusive mind and constantly be evaluating your culture and making those changes. This is a story too. When I talk about mutually reinforcing, Comcast, great company, they have wonderful policies. They have a pretty strong HR function. They have an anonymous hotline in place. Comcast listens. So they have all of the policies in place and the procedures to help the process. Story, in Tennessee, one of their call centers, female was complained of sexual harassment by a supervisor. Apparently, it had been going on for a while to the point where she was really emotionally distressed and she asked to take some time off. She did exercise. She was not comfortable going to HR, which was a curious fact. She wasn't comfortable, but she did use the Comcast Listens. And as that process works, it is anonymous, but they can reach out to the anonymous person and request a call. And so she did accept the call, and she did take the call with Human Resources. So here's where the process starts to break down, intentionally or otherwise. Allegedly on the call with HR, sharing her experience, HR says, I've got another call. I'm going to have to reschedule this. Okay. Does anyone see a problem with that? Okay. Then, this was on a Friday. So apparently over the weekend, the supervisor, who was the alleged harasser, got wind of her complaint. How that happened, we're not sure. And somehow got a picture of her and passed it around and said, she's telling lies about me, which the individual found out from her friends that she worked with who texted her the picture with the caption saying this person is lying. So, as you can see, good anti-harassment policy in place, good process for reporting, no obstacles to communicating, a little bit of a breakdown on perhaps training, and certainly a breakdown on confidentiality and how we treat people who have issued complaints. So we like to think of it this way. Everything needs to be mutually reinforcing. It starts with leadership. Leadership has to be very clear in communicating expectations, in communicating policies, in walking the talk, and in upholding the culture. Your HR policies have to be tight. They have to reflect what, they have to be reflective of what the law is, federal, state, local, and be clearly communicated on a regular basis, not just once. You have permission, by the way, to reintroduce policies anytime you want. If you feel like your department is just kind of going awry, hey, bring everybody together, reintroduce the policy, and say, moving forward, we are all going to be held accountable to this policy. At least you have a way to kind of regroup and get people refocused. Your training and development is critical here. And please, please, please train your supervisors and middle managers, because that's where I think the attorneys in the room will say, that's where the issues happen. They have to understand that they're an extension of human resources, and they are the ones responsible for executing against these policies. HR can't be there. HR can't be the one to have the conversation with the person about the behavior that you, supervisor, witnessed, right? You want to be able to equip them with the knowledge, skill, ability, and I will say confidence, to have the conversations that they need to have to manage people effectively. And then certainly make sure you've got a policy as a backup to cover yourself, right? You can't have an employee practice liability insurance product with nothing else in place, because it's not, you're just going to be spending money and getting no benefit from it, okay? There's a lot of stuff on here, and I'm not going to talk through everything. But for employers, make sure that you have good policies in place that meet the standard of the law, that reflect your culture, and are in compliance. It has to include that clear statement of, against harassment of any kind. Your reporting process, 3 words, please make it easy. Sometimes we, as part of the work that we do, we review employee handbooks, and I'll see an entire page devoted to how to report a complaint. You got to make it easy. If you just say it must be in writing and it must be delivered in this amount of time. I think about my days in the hotel business. We've got probably 70% of the employees are not first language English speakers. So to require that somebody be in writing, right then and there is kind of cutting off their access. So make it easy. Do not have any obstacles to reporting. And please make sure you educate your supervisors and managers to know that, hey, it's okay if Joe doesn't report his complaint to me, Allison, his supervisor. Maybe he's not comfortable with me. Maybe I'm the one doing the harassing. It's okay for him to circumvent that. It's okay. And I need to know as a supervisor that I'm not going to take any retaliatory action against him for having him circumvent the process there. Have that clear statement on retaliation and that investigation process. They talked about, the attorneys talked about it. The one thing that I just want to mention, because I see this more frequently than I would like to, the investigation starts, people get busy, the investigation lapses, more time has gone by, and then nobody circles back to the people involved in the investigation. So if you're going to have a process, follow the process. And if you're going to create a process, make it a process you can follow. If it's too complicated and you're not able to follow it, then it's probably not a good process. But make sure that you use it from start to finish. Train and communicate policies, please, regularly. We talked about reintroducing them. Make sure that you emphasize what harassment is, what it looks like in those training sessions. Make sure that you give examples and scenarios so that they can so that it really comes alive for them. And then very importantly, they know how to report an incident, who to report an incident to, and what to expect. I think that confidentiality piece is really big too, because I don't know about you, but I often hear managers say, you know what, somebody came to me and they said, look, I'm going to tell you something, but I don't want you to do anything about it. I'm just going to tell you in confidence, this is what it is. Don't want you to do anything about it. Managers, what do? They tell you this thing and the flag is waving in front of your face. What do you do? Yes? Yeah, and you can say to them, what you just described to me is not consistent with our culture or our environment of mutual respect. And it's contrary to our policy. And you work with them and you help them understand this, you're an agent of the organization, okay? Managers have to understand that there are lines there and that they're acting as an agent of the organization. Define the processes, be clear on the manager's responsibility to respond to complaints. Let them know. Now, when we're talking with people, we'll usually say, look, 24 to 48 hours from date of discovery. An incident happens that you are notified about. Could have happened last month, but you're notified it now. As a manager, you want to make sure that they're taking some kind of remedial action. That could be reporting it to human resources, but some kind of action within 24 to 48 hours. And then I'll suggest to make sure that all of this is working well, that you inspect regularly, that you as a leader, business leader, that you inspect your processes, that they are being managed in the manner in which they were crafted. And that if you do have anti-harassment policies, that there is not behavior occurring in your organization that is inconsistent with what you have stated. Okay, that's very, very important. And make sure that there are no obstacles to reporting complaints again, and no fear of retaliation. You know, it's interesting. I don't know about you, but do you check your organizations out on Glassdoor? Anybody? If you don't, you should. I always do. When I'm going to visit a client, I always look to see what they're saying on Glassdoor. And, you know, you may, as I have heard, well, I don't believe any of that because anybody could go on there and put that on there. And I have to say, yeah, they probably could. But what if there is some little bit of truth in there? So inspect what you expect. In my mind, that can be a real-time engagement survey. And on one occasion, when I saw the words run, don't walk, describing, I did share that with that employer, suggesting that maybe what we thought we heard is not really what's happening on the ground. Employees, know your policy, comply with policy. Please report incidents. You know, it broke my heart when I heard that young woman in that seminar, the one in particular who spoke up and said, no, they're not going to do anything anywhere, and HR is not going to do anything. Your employer can't do anything about an issue if they don't know what's going on. If you're a supervisor or a manager, you've got to report something. You may think it's an isolated incident. HR is kind of the clearinghouse. They may know that this is not the first time, and it's another data point for them to make some decisions around. Make sure you include, if you're a bystander, that you have a responsibility to upholding the company culture too. So if you see something, say something. Know that you have the right to work in a workplace free of discrimination and harassment. Those are federally, state, locally protected rights, and your policy protects it as well. So you don't have to put up with that kind of behavior. Those women in that restaurant in New York, it's just so unfortunate that they were so afraid of losing their jobs and being treated differently that they didn't speak up for all these years. If, you know, on both sides, on the manager's side, if something's happening, document all the who, what, where, when, how. And if you're experiencing something, I would encourage you as an employee to document and keep notes of when you did go talk to people, who said what happened, what you did. Those are all very, very important. Don't assume it would be a waste of time to report. And again, if you're not comfortable going to your supervisor, go to someone else who is listed in your policy. So tip number 3, mutually reinforcing policies and procedures. Okay, 4, train regularly. Remember, it's not a one-time deal. You'll hear me say it again. The new hire is very important, but maybe not the first day. You know, nowadays you get your handbook sent electronically through the mail in most cases, and you just sign the signature page. How many people do you think really read it? Let's be real. They sign it, but I don't know if they really read it. So in that sense, that 66% of people that don't know they have a policy maybe doesn't surprise me, because technology is replacing that. This kind of a policy is important enough that it should be done in orientation. It should be done again in your department orientation. And then it should be done again with frequency. Annual, ongoing coaching. If somebody is demonstrating behavior, that's an opportunity to pull the policy back out again and remind them. In some cases, it could be a good remedial action to have them reread it, sign again that you have reviewed it with them and that they understand that the kind of behavior they demonstrated is not acceptable. I would suggest having a training strategy. So more than one, really think about it. If today you do one thing, think about how you can make that a little bit more robust. Ongoing coaching is particularly important. Regular messages from leadership. You know, I have some organizations that are very creative. They'll have the auto phone messages that a leader will give if he can't be in all places or she can't be in all places at one time. So they get little injections of messages of inspiration, of culture, of everyone's responsibility in creating a workplace of mutual respect. So they're hearing it in different ways, in different manners. Encourage feedback from all levels. Managers in the room, I hope you roam with purpose, 15 minutes a day. I would always recommend this to any manager. 15 minutes, get up, get out of your office, walk around, talk to people, see what's really happening there. Because that's where you really find out what the temperature of the room is. And then check social media. That's your real-time engagement survey. Invest in training for your managers. I can't emphasize that enough. It has to be done in a timely manner, too. You know, if you make somebody a line-level person, a supervisor, please don't wait a year to put them through that training program. Give them something now. It is a different skill set. It is a different set of responsibilities, and all too often employers take a really good, technically strong person and make them a supervisor and expect them to perform at that level without any kind of training. And manage performance. Hold managers accountable. Document performance for inaction. You know, take those preventative measures, call it what it is. Don't think of it as punitive. Think about it as saving someone's job. I think about the example I gave you from 60 Minutes. Mario Batale's company, gone. The other 2 people, they're separating. Their companies are gone because they failed to take action, so hold people accountable. And then teach them how to have difficult performance conversations, because that's an important tool as well in managing all of this. Last is stand your ground. And when you've worked so hard to build a culture of mutual respect, you cannot allow for any little wiggle room to not take action, to lose that. And I don't know if anyone has ever seen this YouTube video. This is the leader of the Air Force Academy, went viral on YouTube. This was not in regards to sexual harassment, but what it was in regards to harassment, racial harassment. And if you have time, just pop up the video. His name is Lieutenant General Jay Silveria. And what he did was truly remarkable. He stood his ground. The story goes that somebody in the Air Force Academy campus, and they have a lot of different buildings there, wrote some very egregious racially charged messages on the side of a building. Rather than wait, this gentleman pulled his entire leadership team together, the athletic director, the faculty, the administrative, the maintenance crew, and he had all of the students there. And he sent this message. This is just one little piece of it. But he basically said, if you can't treat someone with dignity and respect, then leave, get out. I'm not saying that's the approach that you would use in your organization. But what I think was important is that all of the people there were looking at all the leaders in the organization in a unified manner, same message, very clear. No wiggle room. No wiggle room. This was wrong. And that message was loud and clear. So take immediate unified action, Reinforce that organizational commitment to mutual respect. If you have those core competencies or core values, make sure they're reinforced through everything. And be honest about what's not working. If somebody is not behaving well or behaving in a manner consistent with your policies, consistent with your culture, call it out. Don't wait. Nobody is that valuable that you can be comfortable not addressing their poor behavior, not in today's climate. And hold everybody to the same level of accountability, regardless of their level in the organization. So stand your ground. So just again, 5 tips. Hopefully you take something away from that you can pull into your organization. Remember, preventing harassment is way more than a training session. It's way more than that. It's the way you do business. And I don't think any of you want to be reading about or seeing a story about your organization on the front page of a headline. So, thank you.